roll call, please.
Good morning, Mr. Chairman. This is roll call for October 29th, 2024. Senator French.
Here.
Senator Hicks.
Here.
Senator Ide.
Here.
Senator Kolb.
Present.
Senator Larson.
Here.
Representative Allemand.
Present.
Representative Allred.
Here.
Representative Banks.
Here.
Representative Conrad.
Here.
Representative Craigo.
Here.
Representative Davis.
Here.
Representative Slagle.
Present.
Representative Winter.
Here.
Co-Chairman Steinmetz. Here. Chairman Eklund.
Here.
We have a quorum.
Thank you. So to start, I think I wanted to recognize our president from the University of Wyoming, Ed Siddell. Thank you for coming and meeting with us. If you wanted to say anything, you sure may. Come on up.
Thank you, Mr. Chair and Madam Chair. I just was here in the building and just dropped by to say good morning to you all. I don't really have much to say. I know you have a full agenda, but maybe I could just take the opportunity to say how supportive I feel we are as a university, and I am personally, of the ag program and agriculture in the state. I've gotten to learn an incredible amount about it in the last 5 years, I should say. I like to brag that it's the first job I've had as an adult where I can wear jeans and cowboy boots to work every day, and I really enjoy that. So I think I'm a good fit just naturally. I really enjoy being here in the state. I also would like to say we have a new dean, and I just happened to notice he walked in the back door there. I was going to heap praise on him, but I don't know if I can do it with him right behind me. But I will say we're really, really pleased that Kelly Crane has become the dean, the permanent dean. I think I've never had such an outpouring of support for someone in the role as an interim, but I had calls practically every week from across the state telling me what a great person he is and his experience base. And so we meet together quite often, and I'm really proud that we have him in the role as dean. So maybe that's all I wanted to say. I'll let you can get onto your regular agenda, but if you have a question or comment, happy to take it too.
Mr. Chairman?
Yes.
So,
Senator Hicks.
Is it true that the new dean, that it cost him a lot of money to pay people for that, or was?
I'm not sure how much it cost him, but apparently he had it, so he had enough.
Thank you, sir.
All right, thank you very
Appreciate
much
it.
for having me.
And Kelly, you'll be here around for the rest of the day, and we don't have a full agenda, but I'm guessing we might make it fuller than it looks to me right now. There'll be some changes. You know, first of all, if you're here, we've got a sign up sheet out there. We'd like for you to sign up. And we have some changes to the agenda, and I'll talk about that first. And one of the main ones is on state lands, the grace period. We passed that bill last year that added the 30-day grace period that I think corrects what Chairman Steinmetz and I were trying to correct, which was a grace period for all existing leaseholders, which wasn't as clear in the cure process as we thought it could be. So we passed a law last year that I think will take care of most of what we want to do there. So I'd like to jump over that without objection. It looks like no objections. That'll not necessarily shorten our agenda, but it may move things along. And what I'd like to concentrate on is fencing of state lands. And the reason for that is we've just run into some real problems. And so Anna, yes, Representative Craigo.
Thank you, Mr. Chairman. So I just wanted to note the grace period bill that we all have in our packet applies to new applications versus renewal applications. And the one we passed last year in the director's here, he might be able to fill us in a little bit, but the grace period only applies to renewals, not to initial applications. So if we wanted this consistency between renewals and new applications, we would need to actually move forward with the bill draft we have set in front of us. So just wanted to mention that, Mr. Chairman.
Yes, and I'm not sure that we've had the problems with the renewals that we've had with the present leasees. So, so committee, you're aware of that? Do you want to go ahead and proceed with this? Because I think it's a valid point, it's fair, trying to make the leasing of state lands fair. Go ahead. Senator Steinmetz.
Thank you, Mr. Chairman. I guess if you would permit, I would like to hear from Interim Director Crowder to hear if there have been any issues with the applications, what his experience is, if this is warranted and something that needs to be addressed, or if it's just a true up in statutory language, because that's what I understood it was. We were truing up the application process with the renewal process.
Come on up, Jason.
Thank you, Mr. Chairman. Good morning, committee. Jason Crowder, Interim Director for the Office of State Lands and Investments. I think both discussion points on the first bill are accurate. One thing that I would just like to note is the way the draft bill is written. It's a little bit hard to marry up, and we may have to add some amendments to make sure that the timing is accurate. One of the things inside of 36.1.103 is that deficiency description. It essentially talks about if we go through the whole renewal process or application process, and the applicant simply doesn't finish it, he doesn't sign the final lease, he doesn't finish the whole process, then we're gonna give him 30 days to say, finish it or we're done here and we're gonna move on. That's how we've used it in the past, and that's been very successful. In the maybe one time we've had to use it in my past, that doesn't happen. When somebody goes through the whole application process, they see it to the end, and we don't have to utilize this. It's really the backdrop. But we also use it in case they don't pay their rental, or they do some other lease infraction, that we give them 30 days notice to clean up that deficiency, that lease deficiency. Not a renewal deficiency, but a lease deficiency. We give them that 30 days notice that they need to come into compliance, or we'll start the cancellation process. So that's where 36.1.103 comes into play. Madam Chairman, you are actually absolutely correct that the 36.1.104 that the legislature worked on last year is for the renewal process. And that's a relatively new, really brand new process for us. So we haven't seen a need or a benefit or a negative impact or a change that needs to be done with it, because we just haven't run into that situation yet. It's really new. But what I'd also like to highlight for the committee is the Board of Land Commissioners has recognized this issue in the lease renewal, lease application process. And they've asked me as the interim to come with a policy at their December meeting, so at their next meeting, to see if there's a way we can marry up what historic practice has been as far as reviewing and approving subleases and assignments before that critical period when a renewing applicant, the existing lessee wishing to exercise his preferred right to renew, make sure that he is in line to do that, and he recognizes that there's a deficiency, and that we can be timely if there is a deficiency, if there's a recognized one. So I'm currently writing that policy for them to be able to allow the director to approve an application that comes in during that period of time, and that the Board of Land Commissioners expects that the director does that to ensure that there's no deficiencies of that nature leading into the renewal period where they would want to exercise that preferred right to renew. If the board approves that policy, it will largely clean up all of the issues that we've had over the past couple of years where we haven't been able to honor that desire by the existing lessee to exercise their preferred right to renew.
Chairman Steinmetz.
Thank you, Mr. Chairman. Just a follow up. So if, for example, I'm just going to take one of the the things that happened that I was involved with. We had a lease that was vacated, then they had a temporary lease agreement, and then they had to basically reapply for the lease, which they went ahead and let them go back but if they hadn't gone back to the existing lease, would that be considered a new application that this grace period would apply to?
Mr. Chairman, Madam Co-Chair, this draft bill would apply to that because it would be a brand new application.
So you would consider that a new application transferring from some other kind of lease, like a temporary lease, to a permanent or 10-year lease, whatever it
Mr.
is.
Chairman, Madam Co-Chair, yeah, and the reason for that is a parcel of vacant land is defined as a piece of ground that's not subject to an existing lease. If you have a permit for grazing, that's not an existing lease. If you have anything else that's not a grazing and agricultural lease, that's not an existing lease. So then it does have to go through the whole vacant land process that's described in statute and now in rule. So it would be a new application coming in at that point. What the draft bill does is it allows another 30 days added on to the existing 30 days that are in 36-1-103 to clean up any deficiency in that process. The weirdness is just as I described with Representative Crago, is it's not, the initial 30 days is not to clean up a deficiency, it's to get an applicant, a lessee, to respond after the whole application process, be it vacant, be it renewal, whatever has occurred, and they just haven't signed the lease and they're not responding to us.
So do you anticipate it would be a useful tool in the vacant land, in selecting vacant land applicants?
And Mr. Chairman, from my perspective, I don't think it's helpful at this point. I think that what would be most helpful is the board approving the policy to clean up all of those weird situations where an applicant is not fully compliant. They have some deficiencies, not just in how they filled out the application, but how they're operating their lease. Allow them to clean that up so that they're fully eligible for all of the benefits that are afforded to them for the preferential right to renew and to match any bid that comes in.
Okay. And our statute is fairly clear on how that process could go forward.
Mr. Chairman, that's correct. And that's where the weirdness lies, is the statute allows the director to approve that, subject to ultimate board approval. And what the board has always indicated to directors, past, current and present, is that those applications need to come before the board to be approved, because they need to be ultimately approved by the board anyway. So the director doesn't do that initial approval. But with this policy, there will be that initial approval, and that the board will somehow uphold the director's decision as long as certain criteria are met.
Okay. Senator Larson, do you have a question?
Yes, Mr. Chairman, it's not really a question, but kind of. The director keeps referring to 36-1-103. I wonder if it isn't 36-5-103.
Mr. Chairman, Senator Larson, he's exactly right. I should have opened my notebook and not just spoken from memory. 36-5-103.
Yeah, well, I've been looking at it for several days now, and you get cross-eyed between the two because the actual cure process is in 104, and then 105 is a little different. But anyway, I'm not real good with statutes, it seems like, keeping them straight. But any other questions? So I'll just kind of leave it this way. Committee, what's your pleasure? Looks like we will not proceed because we don't have a motion to proceed with that bill. So thank you. Thank you, Jason. And now we're going to move to one that has gotten quite a bit of attention for several of us, and that's fencing. And I guess I'll have Anna move through the bill. And go ahead.
Thank you, Mr. Chairman. This bill draft is entitled 25 LSO 308, State Lands Fencing. So beginning on page 1, the newly created Wyoming Statute 365119 states that if livestock from privately owned adjoining lands stray onto state lands, the Office of State Lands and Investments or the state land lessee shall be responsible to fence the affected state lands rather than the adjoining landowner. OSLI shall not be responsible to fence the affected state lands, OSLI shall not seek a trespass action against the livestock owner if the only grounds for the action are livestock straying onto the unfenced state lands that do not comply with Wyoming Statute 1128-102. Nothing in this section shall be deemed to limit any liability under Wyoming Statute 1128-108 for state lands enclosed by lawful fence as provided in Wyoming Statute 1128-102. And I can go over what those statutes say if you'd like me to. 1128-102 lays out what lawful fences are supposed to be made out of, and 1128-108 is liability for breach into lawful enclosure by an animal and civil action or arbitration. And I stand for any questions.
Questions, committee? Okay, thank you. So I'll start with you, Deputy Director. Can you share with the committee some of the problems that we've run into concerning fencing on state lands? And we'll go from there.
Absolutely, Mr. Chairman. I think the committee's well aware. We talked at length about it in Buffalo. The best and most recent example is probably the Mosque property outside of Sundance. I wanted to give the committee an update on that issue up in that area. All cows have now been removed from not only the state lands, but the adjoining forest permits have gone off for the winter. So we're in a period where we can look at the situation and address it and try to come up with some solutions. Since the meeting, we have met with the Forest Service, have identified where the issues might be and realized that there's not as big of an issue up there as maybe was talked about at that last committee meeting. The Forest Service has issued what they call private land permits to each one of our state lessees, meaning that any of those cows that might come off of the state onto the adjacent Forest Service property are allowed under that private land permit. And if they do utilize the Forest Service ground under that, and it's a simple incidental type use of a permit. It's not an actual right where they can make it part of their grazing plan. But if they happen to wander over there, they're allowed under that permit. If they take advantage of that, or if they wander over there, the Forest Service will issue a bill on a per AUM basis for that incidental use. And all of that is above board and completely authorized under the purview of the Forest Service. They indicated that all of the parties that we spoke about at that last meeting have those permits, and they have not been issued any bills because they haven't noticed any cattle coming off of the state land onto the adjacent Forest Service property. So they didn't see a problem, quote unquote trespass problem or movement problem with that. Further south in the Mosque property, the names are escaping me at the moment, but they have utilized a small portion of that permit and have issued a bill. Everything was done above board and how it should have been done. What we talked at length about was what happens when the Forest Service livestock come off of that forest permit onto state lands, and should there be some fencing obligation on the part of the state or on the part of the lessee, or even on the part of the forest. Obviously, the Forest Service and the state are similar in this, in that we feel we are sovereign and that the laws granted to or provided need to explicitly discuss state lands and how they are to be managed. And if they don't discuss it, if they remain silent there, then they're not applicable to state land. So the fence out provision, or the case law that describes a fence out scenario, doesn't necessarily apply to state lands. And that's how we've operated since I've been here and for the amount of time that I've discussed with others. However, we do have the trespass statute that's in 36-9-116, and we discussed that at the last meeting, that if you're on state lands without a valid lease or permit or a purchase to sell, you are considered a trespasser at that point. And so we rely on that to tell us that you need to have authorization to be on state lands, otherwise you could be defined as a trespasser. We also discussed that That's not an immediate reaction by the office, that we do reach out to people who are in that situation, try to rectify it through conversations, and elevate it only as needed through correspondence, written correspondence, to tell them that they could be or possibly are in violation of 36-9-116 if they continue to use or have their livestock on that property without a valid lease or permit. And if they continue to not address that situation and we need to elevate it further, then we take it to the Attorney General's office and then ultimately to law enforcement. And as I mentioned before, that's never happened. We've had some conversations about people who are utilizing state lands without a valid lease or permit, and they've corrected it at that point. I think we've sent probably 4 letters in my time with the office, and every one of those situations have been rectified before needing to go to law enforcement. So we've had a good working relationship with individuals in this area. What the draft bill does in that situation would put the burden on the lessee or the state land office to ensure that those adjacent livestock in the Mosque situation from Forest Service property have a fence they run into before they come on to state lands. It essentially puts the fence out provisions currently employed on private lands on state lands. So it could correct that situation, but it puts the burden and the expense where it hasn't been before. And that's just something that I'd provide for the committee. And I see one of the implications of this, if we just forego the trespass situation, where folks do allow livestock to cross the boundary lines, that we create a situation where possibly interior pieces of state land become used without a lease, because it would be on us, on the state, or on that lessee to fence it out. And if we don't, then they can use it for free because they wouldn't be considered a trespasser the way this bill is currently written. So we could provide some amendments if the bill goes forward to the committee to allow that situation, to ensure that those isolated parcels within a ranch or within some type of ownership situation, there's some teeth, there's some leverage to keep it under lease. And right now, the trespass statute does that. Mr. Chairman, that was giving you an update on where we were with the Mosque property. To finish that thought out, I'm sorry. Our field staff are currently up in that area today and tomorrow, meeting with all of our lessees and the adjoining Forest Service permittees to see if there's a solution that we can come to for the next grazing season. They're having on-site meetings. The Forest Service is also involved in those. And so hopefully we can come to some positive resolution leading into the next grazing season. Also, with the Forest Service leadership, we've discussed possibly exchanging out of that piece of property where the Forest Service would own it, and then it could be a consistent permit type situation going forward. They're very excited to see that type of an exchange go forward. If that were to be successful, they would own the whole Mosque property, and we would get the separate, or what's not within what they call the mothership ownership boundary, the isolated sections that are out inside of private land. We would acquire those and manage those like we do every other parcel of state land. But Mr. Chairman, that's the update and how the fencing situation occurred in that situation. It's not unique to the Mosque property. There are a couple others around the state that have the same problem that we're working through.
Okay. So I think, I'm kind of speaking for the committee, but I think what we would like to do with this bill is bring a statute that makes what we're actually doing and practicing consistent with statute. Because right now, there is no fencing required on the state lands by the leasee or by the state. And I'm not sure just how to do that, but we do have some people here who have researched the law, and there's no requirement to fence. And I'm aware of, the Mosque unit I think is a bit unique, but I'm aware of a couple other cases where a bid was put in on land. One of them, they received the lease on the state land and refused to fence it or use it. And another one, I'm not sure, didn't go as that far, would have taken a ranch that had state land intermixed within this ranch, and it never been fenced. And I don't think there's any intention of making a person who's leasing land, I don't know what to do with the vacant land piece of that, but if they are leasing it, I see no reason why it would have to be fenced, so we would have to make that allowance, because that's common practice on state lands. So that's what we're trying to do. We have Senator, we'll go ahead and go to questions. Senator Larson, you have a question?
Yes, thank you, Mr. Chairman.
Else?
I'd like to ask the director a couple questions. I think the first one would be, has the state ever provided materials to build the fence if a leasee requested that? I think I've heard from some ranchers that BL maybe does that. I don't know if that's true, but that would be the first question.
Mr. Chairman, Senator Larson, typically no. And I guess when I say typically, 99% of the time is a no, because the lessees own that improvement, the state doesn't. In contrast, the BLM and the Forest Service will take ownership of those improvements, and so they do provide funding for those, but the state does not, because we don't have any ownership share in it.
Mr. Chairman,
Go ahead.
so currently the leasee would put the fence up, and then if they relinquished that or someone else got it, they would have to purchase that improvement with depreciation, I would guess, or whatever. But that's how that would be handled now.
Mr. Chairman, Senator Larson, that's correct. The legislature did work on that a couple years ago and changed the value type from contributory value to replacement value. So yes, anytime they leave the lease, either through a conflict or through sale, they are compensated for the improvements that they've gotten approved on that lease.
Okay. Senator Ide.
Thank you, Mr. Chairman. Director Crowder, congratulations on your new position. That's good for you. You mentioned the exchange with the Forest Service, with the mothership and the outline. Could you, I kind of got lost in how all of that was transpiring with your conversation. Thank you.
Mr. Chairman, Senator Ide, and this is certainly all conceptual. We haven't submitted an application, haven't gotten anything done, but have had conversations and recognize that the parcel sits between two large blocks of forest property, and that the grazing use has historically been done in concert with those forest properties through forest permits. Not only that, the timber activity, the recreation activity could be done in concert with those adjacent forest properties. So it makes a lot of sense from a management perspective that the public and any other users have consistent ownership in that area. We also, as the committee is aware, acquired that property with help from the Forest Legacy Grant. And that was intended to protect wildlife aspects of the property, wildlife habitat aspects, but also protect it from development. And as you're aware, there's a lot of development in that area being split up into 40-acre tracts. And so this was a way for the state and the Forest Service, through the Forest Legacy Project, to protect it from that type of fragmentation and to keep that forest intact, and then allow us to generate revenue in other ways, including grazing. A transfer to the Forest Service keeps that idea intact. Obviously, they're not going to subdivide it. But we could turn around and monetize that acquisition that we completed, I believe, back in 2021, and acquire Forest Service properties that are outside of the mothership, outside of those large blocks. They have several parcels that are 640 acres and smaller in size that are just out there, and they're very difficult for the forest to manage under their current management regime on large block type scenarios. we would acquire those and manage those just like the shotgun pattern 16s and 36s that we would have. So it, on its face, it seems to be very positive from a bunch of different perspectives, including the beneficiary, the fiduciary responsibility one as well.
Yeah, Senator Hicks?
Mr. Chairman, when you say they've been protected, do they have a perpetual conservation easement on it? What was the mechanism that when those were acquired that protected those lands?
Mr. Chairman, Senator Hicks, there's not a conservation easement on it, but through the deed that we acquired, there was certain types of limitations of use,
Well, there's
mining.
deed restrictions.
Right, correct. And should we sell the property, the amount of money that was utilized, I think it was approximately $4 million from the Forest Legacy grant, needs to go back to Forest Legacy, whatever we acquired to their input.
Okay, that was kind of where I was headed, is how does that play into the sale of those lands? And so-
Correct. And Mr. Chairman, Senator Hicks, and that's why it's attractive to go to the Forest Service, because we would acquire land from them free of those deed restrictions. We wouldn't be utilizing the Forest Legacy grant money going forward.
Okay, any further questions, committee? Okay, thank you. We'll probably have you back up here before you're done. I'd like to call Karen Bud Fallon up. She's probably researched out this fencing on state lands, and might be able to clear up some of the confusion that I've had trying to figure out what's going on. Karen, when you're ready.
I'm Karen Bud Fallon. I'm an attorney in Cheyenne, Wyoming, and I do lots of cases related to state lands. I was asked to specifically do legal research regarding the fencing issue. I would first start out with, there is not a statute or a court case that exempts state lands from Wyoming's fence out requirements. It may have always been done that way, but there isn't anything in statute, or I could not find a single court case that exempted state lands from fence out. There is with regard to the federal government, BLM and Forest Service, National Park Service. Those you've got cases exempting them from a state fence out law, but not for state lands. I would rise in strong support of this bill. I know that the Mosque unit is something that everybody's heard about, and there's been lots of discussion, and that's dealing with federal lands. But there's also a lot of cases now where new lessees have come in or attempted to come in on state lands that were not separately fenced from the prior lessee's private land, and they just turn out their cattle. The problem for the private landowner that surrounds it is that if that land's not fenced, he's in trespass. And so he gets one cow on the state lands, and I'm not talking about whether they, quote, choose to prosecute him or not, because that's a prosecutor's job, that's not my job. But the law says that you can be fined and there's possible imprisonment. So quite honestly, private landowners are not going to chance having their cattle on state lands because the penalties are very severe. There was a case that Representative Eklund was talking about. It was dealing with the Nemo Ranch. They had all sorts of private isolated state land sections. That ranch had had those state land leases for 50 years. So they didn't fence them. There was a competing bid. It was complicated legal mess. Nemos finally were able to retain that state land grazing lease because they outbid the competing lease, but Nemo lost his preference. He was able to outbid the competing lease, so he was able to keep those. But the truth is, fencing that would have been a nightmare. There wasn't any water on the state land sections. The water was all on his private land, but because it was all run in common, it was fine. And fencing out those sections and those pieces of sections, because it was It was not just a 360 or a 640, it was a lot of sections, would have been a nightmare. Kelly Kennedy's facing the same thing on the Burnett lease. That lease was in property that he leased, he lost that lease. The new guy is rumored that he doesn't even have any intent to use it, but he has stated that he did that so that Kelly couldn't graze on the private land. And because that's not fenced, he can't use that private land, nor can he use the BLM land that he has a lease on, because none of it's separately fenced from state land. So I think that this bill is absolutely needed. Mr. Crowder was correct that if you, as a lessee, put up a fence and somebody else acquires the lease, then you're paid for that improvement, just like you put any other improvement on the state lands. And so it may be more money up front for a new lessee, but if they lose that lease, they will eventually get at least some of that money back. The only thing that I saw in the bill that I just had a question on is that there's no time frame. And so if a new lessee gets a section of state land that is not separately fenced from somebody else's private land, there's nothing in the bill that says that the new fence by the lessee has to be completed in the next year, in the next 10 years. And so I just worry about the timing, because in the meantime, the neighboring private land is going to worry about, well, what if my cow accidentally steps over here, or what about the grazing? And so I just had a question about the timing of getting a new lease in. But as I stated, I very strongly support this bill, and I would urge the committee to move and pass this bill. And I'd certainly stand for questions.
Questions, committee? Senator Hicks?
Mr. Chairman, Karen, this substantively would change the way we do not only state lands, but the way we deal with private and private lands. From a standpoint, typically, if I buy, say there's a private section that's an in-holding within your private, and I buy that. Under the current scenario under Wyoming fencing law, we have to share the construction of that fence 50-50.
Mhm.
And so if in a private land scenario, in the very same scenario, both landowners share in the cost of constructing that fence to separate those livestock. And this, we're saying no, because it's state lands now, you're 100% liable for that fence, and you as the leasee or the state needs to go build that fence. And so it sets up another disparaging difference between landowners there instead of providing a consistent fence law across the state. And so that to me is a little bit problematic. It's just now we've shifted the burden to 100% onto one landowner and the other adjacent landowner. And again, if this was a private, it would be they share the fencing cost 50-50. Why wouldn't it be more equitable to do the same thing for somebody that leases this state land to do a 50-50 cost share on that fence?
Senator Hicks, I would not oppose an amendment of that sort. Just a bill that says that the state land and the lessee has to comply with Wyoming state law, and you are correct in your description of the costs under Wyoming state law. And then some protection from trespass while they're building that fence, I would be in full support of that. I just think it is unfair the other way, forcing the private landowner to now bear the full cost of the fence when he doesn't get the benefit of the state land lease.
Yeah, I'm just looking for an equitable outcome.
Yes, I would agree. Sorry, Chairman Eklund. I have to keep my people straight. Chairman Eklund, Senator Hicks, I would certainly
We don't
agree
look like old white
with
guys.
your observation and would support an amendment to that effect.
Thank you.
Yeah, the bill is meant to be a framework that we start from. And I anticipate we'll find all kinds of things that need to be done. You know, as I looked at it, I thought then who receives the improvements on this? if you've got a shared fence, a common fence, because normally half of it, fence to the right belongs to you, and the fence to the right on the other side belongs to him. Well, anyway, we still got more questions. Go ahead, Representative Slagle.
Thank you, Mr. Chairman. Karen, the question I have, I guess, considering this Mosque situation and these other situations you mentioned, I would see that as a hostile takeover type of situation where it isn't like the situation Larry described when a neighbor comes in and buys an in-holding in you and then you agree to share the fence. This would be a hostile takeover, so it wasn't the original landowner didn't want that, most likely, when it happened, the one that had the lease prior. And so I see this as a different situation where you don't have an agreement. And I just thought, get your thoughts on that, because I see it as a different situation than what Larry's described there, even though it's, normally we do share fences 50-50.
Sorry, Mr. Chairman, Representative Slagle, I think this scenario can run both ways. In some cases, you may have a landowner that just simply gives up a state land lease, even though it's unfenced. And so maybe that's a different scenario. In the cases that I have specifically worked on, and I actually, in all 35 years I'm doing this, I didn't have any cases against state land until the last few years. But they have all been exactly what you would describe as sort of a hostile takeover, where you've got a mistake somewhere, and then you've got lessees bidding against proposed lessees, and it's usually not a friendly situation between who's got the new lease now and who had the lease before. But I think that's a policy call between the legislature in terms of who pays for it and how it gets paid for. My main concern is protecting the private landowner who lost the lease and not having, in one of the cases we're working on now, that fence is going to be over $10,000 just to build that fence. And I'm not sure the private landowner should bear that when they're the ones that are suffering because of the loss of the lease.
So, yes, Senator Ide.
Thank you, Mr. Chairman. Just a quick question on that too. That makes you think about a lot of things on this. So if the new grazing lease was put on that state section, just as an example, would it be mandated before they accepted the bid or when they make their bid that they had to fence that section before they would issue the lease? You kind of talked about the timing on this thing too. How long do they have to do it, and what is that time frame? But would the lease actually say that if you're going to lease this, you have to pay for a new fence before you get started on anything? Thank you, Mr. Chairman.
Mr. Chairman, that was the question that I raised. I don't know that it's practical in some cases to say before you turn out you've got a fence, or before the private landowner turns out. I think that's the reason that the bill had that sort of a grace period in it that said that if it's not fenced and the private landowner gets a cow or a sheep on the wrong side, you can't be charged under the trespass civil statutes. I think that was the purpose of that part in the bill, which is on page 2, starting at line 3, is to say they can't trespass the private landowner until the fence is built. So I think that's the purpose of that, was to take care of the scenario you raised.
Yeah. So I'd like to back up a little bit, and I agree with Representative Slagle that the Mosque unit is a different deal. It's a new parcel that the state bought. And this may not, we may be able to work the fencing law for something that would be new like that. But presently, we've just got state leases that are in jeopardy because the private landowners that have had them for a long time are subject to trespass and penalty if their livestock get in when there's an exchange of the lease. And again, we're trying to conform the bill to what's actually done in practice. So what Senator Hicks brought up with the shared fence line we'll have to fit that in there somewhere if the bill proceeds, but with amendments. Any further questions for?
Mr. Chairman,
Okay.
I don't have a question for Karen, but I do have a question for Director on
Okay.
this issue related to trespass. If I could ask that, if you
All
want
right.
to go back, or we still.
Yeah, let's stay
Karen?
here first. Bill, Representative Alleman.
Thank you, Mr. Chairman. Does this bill change 150 years of Wyoming law exempting the state from having to fence out?
Mr. Chairman, this bill simply changes policy. As I stated, there is no law and there is not a single court case. In fact, no court cases have been brought about whether the state has to fence out or not. It is the state's policy.
Thank you. But this would give the state law that they are exempt from being fenced out. Is that right or wrong?
Mr. Chairman, no, I believe it's the opposite. This is telling the state that you have to comply with state fence law on state lands. It's the opposite, I believe, of what you were asking me.
Okay,
if
thank
I'm
you.
understanding your
Thank you.
question.
Other questions for Mrs. Budd? Well, thank you.
Thank you.
Appreciate that much, and you'll be able to stick around a little
Yes, sir.
while as if we start working the bill. Director, would you come on back up? We've got more questions for you.
Mr. Chairman, Director Crowder, I'm contemplating on how if there is a mechanism that we currently deal with as far as these trespass issues, and because I know in my country, it's not uncommon to have somebody has a state grazing lease right in the middle of a BLM grazing allotment, but yet they don't have any BLM lease out there. It's not an uncommon scenario out there in that part of Wyoming. And so is there any provision that you currently have in your rules or the program that what I would say allows grazing agreements? Because in the scenario that I described, the BLM doesn't trespass those guys because they have a grazing agreement in place with the agency that says, I've got this unfenced 640 acre lease from the state of Wyoming, and if my cows move off of that, there's an agreement in place that says that's part of their AUMs in there, and the Bureau recognizes that. Do we have those availability? What I'm trying to do is get away from spending literally millions of dollars on fencing and say, is there a provision rather than trespass that in lieu of fencing, if there's a grazing agreement in place between the state leasee and the private landowner, basically it becomes an in common allotment. And if those scenarios are in place, we wouldn't trespass those. The same thing as the guy that has the state lease that turns out his cow's there, if he goes on to the private. And so I'm trying to figure out a solution here, is if there's a way we can do grazing agreements so we're not driving costs. If you have two parties that can actually agree on that, is there anything in state land that will allow that to happen without a trespass?
Mr.
ahead,
Chairman, Senator
Deputy.
Hicks. Yes, so there are a couple of different avenues we can employ. One would be to further the common allotment thought process, a sublease. You have one lessee, but he's allowing other livestock to use the property and maybe getting paid for that. So we could do a sublease agreement for that. There's flexibility in that process for it. Also, and one thing we did try to employ in the Mosque situation is a temporary use permit to allow for incidental grazing use that might happen. There's some coordination, obviously, with the existing grazing lessee because that's an agreement between the Board of Land Commissioners and that temporary use permit holder without the grazing lessee in play. So we would have to have that coordination, but we tried to work that process and the individuals weren't amenable to utilizing it. I think there are a lot of things that we can use that are currently available to us to allow that type of flexibility you're talking about before we get to trespass. It all needs to have communication, just like with the BLM. We need to understand what the situation is and provide those tools to the guys who are out there conducting those operations to make sure that they're not in trespass. And we do always try to find those solutions as well.
They would have to have a sublease in place if they were doing this exchanging on land they haven't leased that's out in the middle of their ranch. They'd have to have some kind of a sublease on. Well, so I guess where I'm going with this, as our committee's delved into state land issues, I get a few phone calls. And I found out that I think lots of these folks are in violation with what they do. The actual practice will be there's a ranch here and a ranch here and a line fence line right down the middle of them. This guy owns state land on this side. This guy owns something on this side. Doesn't necessarily be state land, but something that benefits both ranches. They work together to come up with a suitable agreement between them, kind of, I think, which was what Larry or Senator Hicks was talking about. But it's being done all over the place. I'm sure they're in violation. And I hate to see people lose leases on something that's working very well the way it is. In that scenario, you'd still suggest subleases, and can they sublease that for long periods of time? I'm talking decades. And okay.
Yeah, Mr. Chairman, thanks for the ability to respond to that. There is a lot of flexibility as long as we're having conversations. I think one of the differentiating points here is when we are having conversations with these individuals, there's a lot of flexibility. It's when the individuals don't get along that we run into trespass. We run into the issues where actually the fence law does need to be employed, and we start having those conversations. And so we are talking about that small part of the bell curve over here where there is no resolution because personalities can't get along. But when we are able to employ our flexibility in all of these, the subleases for any amount of time, really, as long as they're approved and renewed and all of those things, and the coordination with the temporary use permit with the existing grazing lessees, all of that is still available regardless of how the personalities work. But it is that situation we're talking about where folks just aren't getting along. Neighbors aren't getting along.
Okay, and I think what you're talking about is a change in culture that we've probably not dealt with until recently with the people on the land itself, and probably a need for some kind of statute that helps clear up some of the problems we have. Committee, Representative Schlegel.
Yeah, Director Crowder, a question I have especially pertaining to the Mosque situation. If I believe that, or if I understand right, that situation, there were people leasing the land that the state obtained in their exchange or purchase or whatever prior to that. But when the state bought the land, it was just considered vacated at that point in time, and those previous lessees were not even given any priority, if I understand correctly. Is that not correct?
Mr. Chairman, Representative Slagle, it's partially correct. So the previous owner did have grazing leases on the property to various individuals. Before closing and on his own, it wasn't a requirement of closing, he terminated all of those leases. He sent notice and terminated all their grazing rights before the state came into play. When the state did acquire it, we recognized that we were doing that in the winter. I believe it happened in March, and that was a very quick turnaround for an agriculture operation to change how they have historically grazed the area. So what we did was we offered temporary use permits to all of those existing historic grazing lessees and did approve all of those and put them under permit for 1 year while the state land office and those individuals work together to see what a good solution for a longer term lease could be. We asked them what are the appropriate pasture designations, where are the appropriate unit splits, where should they be? And when we got all that information back and conducted all of our field work, we were obligated to offer all of those parcels as if they were vacant, because that's how the statute and the process is given to us. And like I mentioned earlier, they were considered vacant because they weren't subject to an existing lease. Again, the private individual before us terminated all of them. We put them under a temporary use permit, which is not a lease. Therefore, we have to go through the vacant process. And we did that in coordination with all of those historic users. And you're right, when we went through the vacant process, a few of those historic users were not the highest bidders. And there was no preference to be given at that point in time, not like the process we have now.
Has the present process corrected? Would it have corrected what's gone on in the Mosque?
Mr. Chairman, you're correct. So now the vacant land process gives preference to adjoining landowners that allows them to match bids. So yes, it would have, if that's a correction in your definition, it would have changed the scenario, yes.
Okay, so committee, we did pass a vacant land bill, but it came after this Mosque deal went down. Okay, my thoughts on the Mosque deal is it should have been probably resolved by the landowner before he sold it to the state. He could have made stipulations to protect the leasee. But it's a tough deal to fix right now, I think. Any further questions? Okay, thank you, Director. So more testimony from the public. Come on up, Mr. Magagna. Go ahead when you're ready.
Thank you, Mr. Chairman. Jim McGagnon with the Wyoming Stockgrowers Association. We certainly understand that an important issue you're attempting to address with this legislation and that should be addressed. However, I would have to say that as the bill is drafted now, we could not be supportive of it. The primary reason being the one that was raised by Senator Hicks, that you get out into western Wyoming with scattered state parcels throughout these large in common BLM allotments. Landowners own some small parcels of private land, maybe adjacent to a state parcel as well. And that's the way that's operated for 150 years. Different parties who operate within that common allotment lease various parcels of state land. One has another, but it's all used in common. And to say that those would have to be fenced to provide a trespass off an adjacent piece of private land that isn't fenced either, or to even the idea of you'd have to do a temporary or a sublease for those, none of that makes any sense. It's just the way the land patterns are and the way they're utilized. Now, in order to make this bill perhaps as an easy way, I would suggest maybe to make it work with that, would be to say on page 2, line 1, after the or the Office of State Lands may require the lessee to fence the affected state lands. That gives them the flexibility. There's going to be places where it makes sense, they would require it. There's going to be other places where it makes no sense to require a fencing, so they wouldn't require it. And I think one way to approach this would be to build that flexibility into the proposed legislation. The other issue I would arise just as kind of an interest. Yes.
Let's go ahead and work on this portion of it. So we've got an allotment that's state lands in common. It's leased by one person, but there's a whole bunch of leases on the whole BLM, usually BLM allotment or state or Forest Service. Are there any questions? Do we understand what Mr. McGagnon is talking about? Okay, go ahead.
The
more.
other question I raised, because it's kind of an interest, is we talk about this as though everything is fenced out in Wyoming. It's important to remember that cattle and horses are fenced out, sheep are fenced in. So if the adjacent private landowner who's trespassing is running sheep, then it's a simple matter of, the law says he has to fence it. Now, he can require the state lessee to pay perhaps half the cost of the fence, but the burden shouldn't be on the state lessee to see that a fence gets built. That burden lies with the private landowner that's running sheep. So I think there needs to be some, at least look to make sure that that's recognized in here, whether it would take a sentence or just a phrase to say that this is responsible. This would apply to grazing by cattle off of private land by cattle and horses, perhaps would correct it.
Okay. Any questions? Okay, would that necessarily conform what we're trying to do here with what's practiced? I mean, so I'm trying to explain this. Out in the real world where this is going on and we've got sheep out on allotments and they have to fence away from another ranch, do they usually comply with the gentleman's agreement with the right side's yours and the right side from his side is his? Does that happen or is there
Mr. Chairman, I
much
think today
conflict?
characteristically it does. I think that perhaps, and this is historic perspective, that sheep were not included in the process we developed to fence out, because in those days typically sheep were herded. And so they weren't normally trespassing very much because they were kept in control. Today, where we have more and more people, particularly outside of the western Wyoming, the eastern, central eastern part of the state that run sheep in fenced pastures, they need to have fences to control the sheep, but they also need to have that fence to be in compliance with current state law that says sheep are fenced in. And so I think it has worked relatively well.
Okay, so okay. Senator, go ahead.
Thank you, Mr. Chairman. Quick question. That first amendment you mentioned on page 2, I think you said line 3, change shall to may. Is that, am I in the right spot there? I didn't get to it quick enough when you were talking, and then there was some other language to go with that. Thank you, Mr. Chairman.
Mr. Chairman, Senator Ide, what I was suggesting on line 1, and if you back up to page 1, it says that the Office of State Lands and Investments or the lessee shall be responsible. I was saying, if you're gonna leave state lands as a responsible party, then say, or the Office of State Lands may require the lessee to be responsible. That way, if the circumstances justify their imposing that requirement, they have the full authority to do so. If the circumstances, like in the common allotments, don't justify that imposition, then they're not obligated to do it.
Okay, backing up to what you were previously talking about, sheep and horses and cattle are required differently, fence in and fence out. Are you suggesting then the bill should only apply to cattle? Or, because we may get into as many problems doing that as otherwise.
Mr. Chairman, I would be suggesting that the bill is only needed to apply to cattle and horses, because in the case of sheep, the existing state law requires that private landowner fence the sheep in.
Okay, not horses? The horses aren't, I thought. they were-
Horses have always been determined to fall in the same category as cattle.
Okay, yes. All right. Representative Crago.
Thank you, Mr. Chairman. Mr. McGagnon, so when we're talking about the difference between sheep and cattle, I mean, obviously I know the difference. I know how we talk about that generally speaking, but in this particular circumstance, and I'm not sure the bill gets to where we really want to go, because what we're really talking about is when someone goes and grabs the state land in holding within someone else's privately owned ranch. And that could be a 640 or it could be 5,000 acres. It just depends on the place. And let's say that's historically been a sheep outfit, right? And so the sheep outfit has their boundary fences completely sheep tight. But now we're gonna take a 5,000 acre chunk out of the middle of that ranch and we're gonna make the sheep rancher, because for whatever reason, he lost the state land lease. Now he's gonna have to be responsible for fencing that 5,000 acres. I'm not sure I agree with that in that particular circumstance. What are your thoughts about that?
Mr. Chairman, Representative Craigo, in that particular scenario, it's certainly not justifiable. I mean, it imposes an incredible burden. Unfortunately, that raises a much more fundamental question we can't address here today. And if I totally surround a parcel of state trust land, should there be some flexibility in the Board of Land Commissioners to say it simply doesn't make sense for grazing purposes to lease that land to someone else? I mean, the reality is it doesn't make sense. Whether we want to go down that path, that's a whole different issue for another discussion. But because under the existing law, as it is, even without doing anything here, that sheep producer would be required, just the same as if that were a piece of private land in the middle of his private land, he would be required to fence the sheep out.
Okay. Other questions? Oh, yeah. Chairman Steinmetz.
Thank you, Chairman Eklund. I feel like we're getting a little bit confused in the fact that we're talking about a construction of a new fence, construction and maintenance of a partition fence, which in law talks about half would, go to it. They're supposed to split that. And I get the different livestock have different requirements to keep them in the fence once it's built. But at the same time, if you're constructing a partition fence, it talks about, each party contributing half. So are we off in the weeds here by talking about what animals we're talking about? Or if we're talking about a partition fence, which is this a partition fence? If it's a partition fence, everybody has to pay half. If we're going to say that we're going to have the lessee or state lands comply with building a partition fence, because I guess I need the division in my mind as to whether that partition fence because there could be different livestock on there at different times. What we're talking about is constructing a partition fence where there hasn't been one before. So to me, that's pretty clear. If we're going to have state lands comply with constructing a partition fence with current law, which is 1128-106, then each person is required to pay half.
Mr. Chairman
Go
and
ahead.
Chairman Steinmetz, you're entirely correct as to the payment part. The difference I see is that we already have a law that puts the burden to initiate the fence construction on the sheep producer. And then he can require the other person to pay half, as opposed to the other scenario where it's the person who's being trespassed on that has to take that initiative. And my concern is that we're now doubling up. We're saying under existing law, Mr. Sheep Producer, you're required to build a fence. Now we're imposing that same requirement on you under another statute we're passing in a different part of the law. And but that was my point, is that scenario is already covered, so why are we covering it again in this part of the law? And that would be up to your decision, of course, but the initiative in the case under the existing law, it's the sheep person's responsibility to arrange for the construction of the fence. And as long as it's a legal fence, not more than that, they can require the neighbor to pay the 50%. So it would just be imposing, I agree, basically the same financial requirement on them, but doing under two different entirely different sections of the law.
Follow up
Yeah, follow up.
for a sheep producer, but if we're talking about applying this to state lands who hasn't had to fence a partition or a lessee that just gained a lease in the middle of a ranch like Representative Crago was talking about, and they're not a sheep producer, so are you saying that the partition fencing needs to be applied by species? If we're talking about this, I understand what you're saying, that you're saying the sheep producer would have to initiate it, but it's still I mean, even if it's a sheep producer and this happens in a sheep ranch, we're still saying state lands would have to abide by that is what we're trying to get at. That they'd have to pay for half the fence.
Mr. Chairman and Senator Steinmetz, they would have to pay for half the fence, yes. State lands or the grazing lessee, however you place that responsibility, they would still have to pay for the fence, but it would be the sheep producer who would be responsible for initiating the construction of the fence, or if he's herding his sheep or that and he can keep them from trespassing, then he wouldn't need to construct a fence. That would be his other option.
Okay, thank you.
Okay, any other questions for Mr. McGagna? Thank you, sir.
Mr. Chairman,
We've got one over here. Sorry, Dan.
thank you.
Yeah, Senator Larson, go ahead.
Thank you, Mr. Chairman. I would like to ask, if a fence was built, I would guess that the cost would only be shared on a lawful fence, not specifically for a sheep type fence. Is that not correct?
Mr. Chairman and Senator Larson, I don't have the statute in front of me now, but I believe the statute on lawful fence defined what is a lawful fence for sheep. So in that case, the fence that is built would have to, in order to require the state land lessee to pay half, it would have to, you could be required to pay half of a fence that's built for sheep. And Senator Steinmetz, I believe, has that law in front of her. Perhaps she can correct me.
You know, I had thought it was lawful fence was a 3-wire fence, which which
Miss,
keeps a lot of sheep in.
Okay.
Mr. Chairman, I think that is correct. I don't see where a sheep fence is specifically stated.
I apologize. I believe you are correct. It's a lawful 3-wire fence, or there's some stipulations for wooden fence or that, which is likely going to be built. So the sheep producer, in order to keep his livestock off, would have to build a fence that's adequate to control the species of animal that he's running.
Okay. All right. Any other questions? Thank you, sir.
Thank you.
Other public testimony? So, Mr. Kennedy, when you're ready, just go ahead and tell us who you are.
Okay. I've never done this.
Yeah, get up to the mic so everybody, you're kind of on the air. I hate to
Uh-oh.
inform you of that, but you'll be okay with it. Go ahead, speak into the mic, make sure it's on. It's got a green light.
Okay.
It's on. Good.
Yeah, it is on. Thank you so much for for looking into this problem. This is actually,
Could you state your name?
oh, I'm sorry.
Record.
I am Kelly Kennedy.
Okay. Thank you.
And this happened to me. And so I would like to start, I handed out a sheet. The second from the last page will show the map of how this land lays. And I guess I would like to start with saying that 10 years ago, this month, actually, I bought Burnett's Ranch from him and the main part of it. Steve kept this portion that you're looking at here today, plus 100 and some acres on Sabile Creek. where he was running his own cattle and everything, and I was running his cattle on shares the whole time, taking care of them and everything. But it was his cattle running on his property, or his lease and all. And 2 years ago, I made a deal with Steve and bought the cattle. Did not know and did not even think about changing and having a sublease in place. And so the state, I'm not sure where to bounce around to, but anyway, the state said we needed a sublease, and so we did all the sublease. And it was approved in December before our lease expired and everything. And we paid the money and everything because a person that owns 35 acres jumped our sublease. And so we matched the funds and wrote the check, and it was all approved and everything. The board had done, I don't remember the figures, like 25 of these things that day, approved subleases that were in violation for many years, as it's written in the paper you have. But 6 months later, they came back and said, no, we could not do this. The state said we were in violation, and so we could not carry on. And so they have created this problem. And I think they have to pay for all the fence that they have created over lawful buying. And it's going to create more problems than just this. Our cattle, if they do fence it, still cannot trail back and forth between these pieces of property. Steve Burnett, when he sold it, he reserved the right to graze it until they fenced him out. So a lot of this is all 35-acre subdivisions up there. Just like the Kite Ranch, if anybody knows about the Kite Ranch, same people did it. But within that, we also have 3 different partials of BLM ground that you can see. And it'll limit us being able to get to them even if it is fenced. The 140 that touches the state on the one side, we would have to trail across the state to get access to it. And the person that has taken over this lease will not sign a trail permit so we can even access it. Or to go across back and forth between the piece Steve owns and the rest of it, it's a lot shorter and more convenient because that's where the trails are. Otherwise, we're gonna have to go plumb around. And one thing another too, the person that they gave the lease to has never owned a cow. He just wants to stir the pot. He has done a lot of things, including one neighbor, he's pumping stock water out of their stock tanks on state ground, hauling it to his place and dumping it in a pond for his ducks. He is retired and has nothing better to do than to stir the pot, in my opinion. But they have created all this problem. The least is that they should be able to, he should be responsible for all the fence. And I think it should include in this term that he has to put in a car gate too, because this partial goes across the county road. And he has created all this problem, and between him and the state, I do thank you for the right to cure or whatever that you passed, because that's what the state claimed we did not have and took the state lease away from us, which I do not understand why they would ask us to do all this. And after 6 months after they approve everything, they go back on their word on what they did. And I don't know where to go with all this, but this guy is always packing a pistol on his hip and he's looking for a fight. And if the state does not solve some of these things, there is going to be problems. Maybe not with this lease, but there will be others. And I don't know why the state went there the last year, they did not let anybody graze this, so they lost, I mean, we're talking $1,600. It's not a big thing because it doesn't really have that good of water or anything else. Our cattle actually water out of the creek and utilize this. They're gonna have to haul water for this piece of partial, so it's just somebody that wants to be a pain in a lot of ways, but now I lost my train of thought. But anyway, yeah, they have created all this problem, and what I would really like to do is actually go back some way or another and split this piece of property. This individual was illegally grazing the 80 acres with his horses already, so he is in violation. I don't know why the state decided he was the person to give the leases to and create all this problem. But I would like to go back somewhere or another and split this, and that would eliminate all the fence. I have went into mediation and everything with him. I have tried to even give him what lays on the west side of the hill, which would be the 40 acres and a lot of unfenced ground. I would pay for the car gate and everything. He could water his livestock out of the tank that he's already watering illegally on the piece of state ground and everything. But he would not go for that. He denied that. And so I've kind of at the end of my rope, hoping you guys can help me. Right now, what his real goal is trying to keep me from grazing the rest of that ground. And he has successfully done that for 2 years, and including our BLM leases or Steve Burnett's BLM leases. And I don't see why the state did this and why they did not look into it when I wrote them a letter and sent them pictures and everything of the violation of the guy grazing his horses on this property, including another landowner that took and sent a letter to the state also, and the state did nothing about it.
Okay, so I think probably, Mrs. Bud Fallon, would you like to add things to that before we proceed on, or I think there are gonna be some questions, but what would be your preference?
We can do it either way. I represented Mr. Kennedy, and so I was up here in case there was a question that he couldn't
Okay.
answer.
All right, we'll go ahead with questions. Are there questions for Mr. Kennedy or his attorney? Okay, so I guess a question to kind of clear it up, this portion of private land was retained by Mr. Burnett. You were leasing it from him. Mr. Burnett turned it into a housing development, and it's been split up into 35-acre allotments.
Yeah, he's did that many years ago. I mean, probably started over 20 years ago, subdividing it and selling off pieces and everything. These Jerry Lawfulbein and Dan Taylor are two people that actually bought 35-acre lots, and that's all they own. And like I say, they've never owned a cow or anything. They just, and it's Lawfulbein is the one that's actually pushing all this. Dan Taylor, I've met him once. He's not involved really. They just formed a thing so they could get the lease. That's all.
We have got a question online. So Senator Larson, you have a question? Go ahead.
Yes, Mr. Chairman, thank you. I don't know if this is a question for the person that's up there, maybe more so for the Deputy Director Crowder. I guess it's Director Crowder, sorry. Is there any rules in the Office of State Lands and Investment for trailing livestock across the state lands? I guess that's the question.
Okay. Director Crowder, you can come on up and answer some questions too, if you'd like.
Thank you, Mr. Chairman. Senator Larson, So there's not a specific set of rules that talk about trailing, but what we have is the temporary use permit that we spoke about earlier that allows access, and we've used it for trailing in the past that gives the second individual or that third party a right to utilize the state land to trail his livestock across to get to wherever he needs to go. So yes, we have the temporary use permit available for that.
Mr. Chairman, so what's the time frame on that? Is that pretty much just contact the office and request that by phone, or does that take a written request?
Mr. Chairman, Senator Larson, it's relatively quick. It is an application process, so they do need to submit forms into the office. Temporary use permits are available or eligible for the director to pre-approve those, and then they get ultimately approved by the Board of Land Commissioners. What has been spoken about earlier as far as other requirements in that process is that there is a surface lessee consent that does need to be signed by that existing lessee and provided along with that application. With it comes a consideration for however many times or the extent of the use that needs to occur, as well as a surface impact payment to that existing lessee.
Mr. Chairman, a follow-up. My question, I guess the question would be, what if the consent cannot be gotten?
Mr. Chairman, Senator Larson, great question. So we expect that the effort is undergone, that they try to reach out to that existing lessee and try to mitigate whatever impacts might be there. But if it simply can't be secured, then we expect the applicant for that trailing permit to come into the office and tell us they can't secure it. We'll provide that information to the Board of Land Commissioners to say, these are the reasons that the existing lessee won't provide consent. And ultimately, the Board of Land Commissioners gets to make that decision on if the permit should be approved or not.
Okay, Mr. Kennedy.
We filled out an application and Steve took it up to Mr. Lawfulbine the other day and he denied it and will not sign it. So we have tried that, and we've tried mediation, we've tried a lot of different things, and I am at the end of my rope. I mean, and I really think a lot of ways this guy really wants just to keep us out.
So in this case here, where there's been an application for a trail permit and it's not agreed on by both landowners and the trail permit is not given.
Mr. Chairman, we haven't seen the application. We haven't been given an indication that that conversation has occurred. But now that we know, we'll take the application if Mr. Kennedy still wants to submit it, and we'll work it as if the Board of Land Commissioners needs to make that determination on consent or not.
So normally is this application for a trail permit agreed on ahead of time? Because you're suggesting it doesn't have to be agreed by both landowners.
But Mr. Chairman, the consent is typically agreed to beforehand. The application, if it doesn't come with the consent, doesn't always have to be married up like that. We just expect the consent and not just a comment. I guess that's the differentiating point here. To get into the weeds just a little bit, when you have a new lease coming on top of an existing lease, there's just a comment requirement. But when you have a permit coming on top of a new lease, there's a consent requirement. And so if the consent cannot be provided by or won't be provided by the existing lessee, that's not a showstopper for that permit to move forward. The Board of Land Commissioners still has the ability to make that final decision.
Okay, Chairman Steinmetz.
Thank you, Mr. Chairman. So in this case, the next step is to submit this application to you and let you know that the landowner would not consent to have a trail permit. Then the Board of Land Commissioners will make a determination. And if they determine that there should be a trail permit, who enforces that so that there are no problems between the landowners, and what does that look like?
Mr. Chairman, Madam Co-Chair, it is an agreement between the Board of Land Commissioners and that permit holder. So we're going to ensure that both parties are given the rights that they've applied for, that the Board of Land Commissioners has approved. If there happens to be a conflict between the two, we don't have an enforcement arm, we don't have law enforcement. So we'll utilize the Sheriff's Department to separate the two or to allow the two to coexist. But the sheriff will use the permits and the leases that have been approved to each individual on the property.
Follow up, Mr. Chairman.
Follow up.
So if Mr. Kennedy is given a trail permit and he has any problem utilizing it, he calls the sheriff, is that what you're telling me?
Mr. Chairman, Madam Co-Chair, correct, because he has that valid permit in hand.
Okay, thank you.
Okay, committee, Representative Craigo.
Just a quick question for the director. So if the current lessee does cause all sorts of problems with that permit, the trail permit, does that subject him to termination or cancellation of his lease?
Mr. Chairman, Representative Craigo, there's not a requirement in his lease that he that he quietly, I guess, allows the enjoyment of other permits on there. There is an expectation that there are other permits that could be approved, but if he decides to cause issues in whatever manner, that's not typically a violation, or that is not an explicit violation of his lease. It's simply he's infringing on the rights of somebody else who's been given a valid permit or lease.
Okay, any other questions? Yes. Senator Ide.
Thank you, Mr. Chairman. Just a real quick question for Mr. Kennedy. So you're in Platte and Albany County. Can you be a little more specific? I'm sorry, I'm not familiar with where your ranch is, just to kind of get a little visual on where you are here. Thank you.
Okay. My grandfather homesteaded over 100 years ago in the halfway between Rock River and Wheatland, right up on the range, and that's where I was raised. The ranch has been divided a couple times since then. 10 years ago, I divided with my brother and moved to Wheatland and bought Steve Burnett's, and that's where the Platte County comes from. We still own ground in Albany County and everything, and tried to make a deal with the state on, but did not go through, and I partly feel like some of this happened here because Jason Crowder and I butted heads on that deal, and I really think that's beyond the point. But anyway, so that's the reason I'm in Platte County, but I still own ground in Albany County, and that piece of ground that we were trying to sell laid in the corner of the Mariah, and the state of Wyoming would have owned all the water rights above them. It would have been a great deal for the state, but they backed out on it, and 6 months later, or less than that, I sold it to a private individual for exactly the same as I was asking the state for. So, and I still lease it. So thank goodness the state didn't get it, or I probably wouldn't have that lease either. But we have even met with the governor's office and tried to do some mediation. And when we met with him, Jason Crowder said that if I turn cattle out on that ground, on the regular ground, the rest of the ground, could be under criminal trespass. But the guy that jumped my lease, if he turned out cattle on it, it was a fence out state, it was my problem.
Okay, Senator Ide.
Just a quick follow-up. So the conflict area is in Platte County near the town of Wheatland, effectively?
Yeah.
Okay, thank you.
So, Director Crowder, this committee's passed several bills trying to correct these kind of problems that have come up. Under the present law that's been passed, and I think most of it's been enacted and is in use, would the problems we have here have been resolved through the statutes that we passed in that cure process and maybe others?
Mr. Chairman, they would not. What you passed was a cure process to correct deficiencies in the application. What Mr. Kennedy is alluding to is a violation of his lease to be eligible for the preferred right to match a conflicting bid if it was higher. Your statutes don't correct that. What I spoke about earlier at the beginning of the day, the policy that the Board of Land Commissioners has asked me to write that will allow them to approve that sublease, as Mr. Kennedy referenced, in a timely manner, so that we're not in this situation, that would correct this problem. And so that's what we're working on for the December meeting, is that policy that allows the director the authority to approve subleases if they meet certain criteria, and not require them to go to the next regularly scheduled board meeting for approval. If that happens, if that's approved, then this is corrected, and that utilizes existing rule and existing statute that's been in play for quite some time. But what it does is it defines the director's role in approval and the board's subsequent role in final approval of those agreements.
Okay. Yeah.
Just to
Mrs.
add a
Budd.
little bit to the facts, what happened in this case was that Mr. Kennedy had been leasing Mr. Burnett's ranch, but running Mr. Burnett's cattle. When he bought the cattle and then subsequently found out he needed to sublease for the state land, Mr. Burnett had already reapplied for his state grazing lease. The State Board of Land Commissioners approved the sublease before the end of the appeal period, but the State Lands Office said that wasn't good enough and still took the preference right from Mr. Burnett or Mr. Kennedy. So even though the approval occurred before the end of applying for the lease, because Mr. Burnett was trying to apply early and get the paperwork done, he was penalized for that.
And it was 6 months later, after I turned cattle out, that and I mean, it's just a trailer load, but the director had changed their mind. It was approved in December. In May, they changed their mind. And so I had to spend days gathering 12 head of cattle, or 14, I don't remember, that were not on state ground. But I was trying to be nice and get along.
All right. Questions, committee? Okay, so in the process, a sublease, long-term sublease, or whatever, had that been in place before he purchased the cattle, then the state land process would have worked to
Mr. Chairman,
avoid this.
that is correct, yes. And if I can just add, this issue, while unfortunate, has gone through the Office of Administrative Hearings, and they agreed with the determination by the director. This issue has gone through the Board of Land Commissioners, who upheld the decision of the director, felt it was appropriate. And this decision, the decision by the Board of Land Commissioners was available to appeal through the district court. And that decision, or that time period, has lapsed. So this issue has been, I guess, considered at great length by a bunch of different bodies, and I'm not an attorney to tell you all the right words to tell you how that process went on. But we understand that there is an issue with the timing period, and that the Office of State Lands and the director's decision was appropriate through all of that. And that the Board of Land Commissioners has now given me direction to come up with a policy using existing statute and existing rule to find a solution, which we feel we can, to correct any of these types of situations going forward.
That was done after this.
Mr. Chairman,
Okay.
that's correct.
All right.
And Chairman, one thing I think the state should look at also is how much did this cost the state to make this stupid decision? I mean, how much did they spend in time and money and lawyers? I know I spent some in lawyers trying to solve this. I mean, and now we're looking at trying to, and I think Jason and Lawfulbind have created this entire problem. So I think they should.
So I'll ask you to be careful, because it's been
I'm
through
sorry.
several levels, and we're just
Okay.
not gonna attack each other
Yeah,
or
I'm
get
sorry.
off the subject, which is
the state lands and lawful bind should have to put in the fence, and I shouldn't be penalized for losing a lease. Is a better way, I'm sorry.
Okay, any other questions, committee? Yes, Representative Alderman, go ahead.
Thank you, Mr. Chairman. Mr. Director, would this bill help this problem at all? If we pass this bill today and it passes the body and is signed, I don't see too much in this bill that will help Mr. Kennedy.
Anyone?
Yeah, Mr. Chairman, Representative Alderman, I'm not sure. I've not thought about that, if it would or not. What I do think is that it does create a fence out scenario for state lands, and so possibly it would impact their conversations. But as I mentioned before, the statutes, the fencing statutes and everything work really well when you have two neighbors that work well together. And I'm not putting the state land office in that neighborhood of neighbors. This is the lessee versus the adjoining landowners or adjoining leaseholders. And so when they don't work well, I'm not sure if this will totally fix the issue.
Follow up, please.
Okay.
Thank you, Mr. Chairman. We're got a lot to think about here. Do you need this bill now, or can we table it and do some work on it? Because we've been in the weeds talking about sheep. Now we're talking about all sorts of things. Do we have time, or do you need something pretty soon?
Okay, Mrs. Bud Fallon, go ahead. She might be able to answer this bill.
With regard to this bill, I think that as Senator Steinmetz said, I think we're getting into lots of weeds when the bill is a fairly simple concept. It actually would help Mr. Kennedy because it would require, all right, I actually believe it would help Mr. Kennedy because it would force the current lessee to fence that state lease away. Mr. Kennedy had lots of other problems and lots of other issues that aren't addressed by this bill. Can't be addressed by this bill. I have not seen the new policy. Hopefully there's a chance for public comment on the policy so that we can see if it addresses some of these other issues, but I think the current bill would help now. The question that I was raised is, as people were talking and I was sitting in the audience, is right now, even though state of Wyoming requires that both parties contribute to a fence, Mr. Kennedy ends up building the fence. I'm not sure who we would send half of the fence bill to. There's no provision for the state land office or the current lessee to pay for half of a fence. If that's where the committee decides it wants to go, is to follow current state law and paying for part of the fence. So I think there has to be a mechanism. If you're gonna pay for part of the fence, I think we need to include that somewhere or require the lessee to pay for it. But it would help at least a small part of Mr. Kennedy's situation right now if we pass this bill.
So I guess a question I've got for Anna, because this bill would be from more than likely July before we'd get this thing enacted and through, if it can make it through the process, will it apply to previous fencing problems that we have existing? More than likely won't help Mr. Kennedy, but it will help others with the same problem later on. Okay, just so we're clear on that.
Mr. Chairman, it wouldn't be retroactive,
Yeah.
no, but we could have it effective immediately if you'd like, instead of July 1st.
Sure,
So,
sure, but it still will not help the
no.
present problems that piled up here. Oh,
Well,
Okay.
present problems, maybe. I mean, if it's still ongoing as of whenever the bill is effective, but it's not gonna be retroactive.
okay, I'm still not very clear on that.
Mr. Chairman.
Oh,
Thanks.
Senator Larson, go ahead.
Yes, Mr. Chairman, I'm just responding to your question. I think it would be because you would have animals straying on state land.
Okay. Good point, thank you. Mr. Kennedy, go ahead.
Another thing that makes this a little more unique is we don't own the ground next to this other than Steve's 35 acres. So, you know, it really isn't our, I don't know how to say, a place to put a fence on somebody else's property. We have the rights to graze all of it until it's fenced, but we don't really have the right to fence the state in or anything either, you know? And there's two BLM pieces. And the way I understood it is the BLM trumps the state, so the state needs to fence away from the BLM. Is that correct or not?
I don't know. Anyone know that answer to that? Karen, would you?
I am guessing the BLM would argue that state fence law in no situation applies to it.
Mr. Chairman?
Yes, Senator Steinmetz.
Mr. Chairman, I feel like, we're gonna have to get a little bit back on track here in the fact that we don't want this to look like this is a bill for one person. This is addressing issues across the state. We've heard about these issues from other places, and so I think if we get into the weeds too much on one situation, while we appreciate it and we appreciate you coming here and sharing with us everything that you have to help us inform our decision, we would never want to look like we're crafting special legislation for one person in the state. So I just wanted to put that out there a little bit, Mr. Chairman.
Thank you for that reminder. Senator French.
Thank you, Mr. Chairman. To the director, Mr. Crowder. So if Mr. Kennedy comes to you with a request for a trail permit across that state piece, is that something that you will, do you consider that? Do you approve something like that? Thank you.
Mr. Chairman, Senator French, that's a good question. So the director has the ability to pre-approve applications. If an application comes in without consent, I don't know that I would feel comfortable approving that without ultimate Board of Land Commissioner consideration, because there's an implication possibly to that existing lessee, and the Board of Land Commissioners holds that ultimate authority. But if an application comes in without consent, absolutely, we'll move that forward and consider it just like any other application that comes in.
Okay. Senator Kolb.
Yeah, thank you, Mr. Chairman. So a little uncomfortable sometimes commenting about these complex fencing issues, but if I understand this right, Mr. Crowder, you've indicated that you're going to have a solution for this situation in the near future on a rule change. Is that correct or not correct?
Mr. Chairman, Senator Kolb, the clarification is we will have a solution for the renewal process. That there is a very small amount of time that Mr. Burnett was not eligible to exercise his preferred right to renew by matching the highest bid. We're fixing that problem. If that problem's solved, then this problem we're talking about with Mr. Kennedy and the new lessee doesn't exist. So we're not addressing a fencing issue through that policy addition. We're addressing a lease renewal and allowing deficiencies in the lease operation to be corrected in that small amount of time.
Follow up. So this situation won't exist as it is. If you go through the new rules and change those, the timing issue. I mean, it sounds like you said, yeah, it's not gonna exist as this current problem's gonna go away because of the policy you're gonna change.
Mr. Chairman, Senator Kolb, future situations that are just like this, correct?
Well, can you fix this past situation then? That's maybe, okay, let me rephrase. Can you fix this past situation? That's what I want to know.
Mr. Chairman, the application for renewal, the director's decision, the conflicting application has all been vetted, it's all been considered, it's all been approved by the various bodies that I spoke about earlier. We have a current contract with a new lessee that we can't back out of. There's not a legal reason to do that. So no, there's not anything that we can do to solve the situation that's presented to you today. Back to where it was.
Yeah, Senator Hicks.
Yeah, Mr. Chairman, I'm gonna try to get us back focused on the bill, but specific questions, because I think we need to understand the ramifications of one example applied across the state. So how many acres of state trust lands do we have in the state of Wyoming? And I can't remember, but at one time it was 78,000 parcels. So the number of acres and the number of parcels.
Mr. Chairman, Senator Hicks, I don't remember the exact number of parcels. I think we're over you could be correct, but the number of acres is 3.4 million surface acres.
Yeah, 3.4 million. And Mr. Chairman, my recollection, and it could be off a couple thousand, but it was like 78,000, I believe, or different parcels scattered around the state of Wyoming, because this law would effectively impact, if I have 40-acre grazing lease in the middle of you, that 40 acres has got to be. So, I mean, there's just, for my neck of the woods, this has giant ramifications. And so I'm a little comfortable trying to take this bill and apply it without significant public comment and review as to the implications of this bill associated with all of those. As you guys well know, I have the largest Senate district in the lower 48 United States, and there's a lot of state leases out there. And I'm real concerned, given the nature of the magnitude of the impact of this bill could negatively impact a number of those, and without a substantial more public input on those consequences. I just think this bill needs a lot more work, Mr. Chairman. And I understand they're trying to resolve Mr. Kennedy's issue, but his issue cannot affect the other thousands of permits he's negatively affect. And I don't know whether it would or not. And I would like to have an opportunity to hear from them. And I think that's kind of what we heard from Mr. McGagnon. So I just think we need to probably either form a subcommittee, or we lay this back and we take it up in the interim, because it has giant ramifications.
I agree. What we've got here was meant to just be a framework to start from and a conversation to have as to whether we're gonna pursue the idea that the state land does need fences. Representative Slagle.
Thank you, Mr. Chairman. I guess in comment to Senator Hicks's concern, I see maybe we just put something in this bill that says when a lease has been vacated by the state and comes up being leased by a new lessee, at that point in time, if the fence determination is there, it needs to be made. Otherwise, I mean, I don't see this as something that we need to go out and fence every parcel of our state land because we come up with a law like this. It's just in situations like the Kennedy's case, the case up in Mosque, and several other cases that we've discussed this morning that this applies to. It's not a blanket deal saying, okay, the state needs to fence all their land out at this point in time. And I mean, I guess what I see is it comes up when we have these conflicting lessees coming in that are coming into a inholding in somebody's ranch, or a change of ownership like the Mosque case. I don't think this applies. And it might be, it does apply to all state land the way it's written right now, but I think it only takes effect if we come into these adverse situations, is what I would say. Thank you.
Thank you. And I'm not sure we can separate those out and just have them apply to that part of state lands. Maybe we can. Any other questions? Oh, yes. Senator Larson, it's hard for me to see your hand.
Mr. Chairman, thank you. I would like to, I think we need to discuss this bill, and I guess at some point we need to decide if we're going to move it. I don't know if we're at that point or not.
Yeah, we're not finished with public comment, so let's go ahead and move on. Other public comment, anyone? Thank you, Mr. Kennedy.
Thank you so much.
Karen. Welcome to our committee, Mr. Moline.
Thank you, Mr. Chairman. Brett Moline, Wyoming Farm Bureau. Just a few points I wanted to make. There is some subtle differences with state land, state school trust land fencing. In most instances, if it's between private and private, two private entities, the fencing will belong to the private landowners. With state school trust lands, the fences essentially belong to the leasee. And then if they lose that lease, they can get reimbursed. They can sell their fences essentially. So in this instance, because of the differences, it probably should, the responsibility for the fences should be on the school trust land, leasee, or the state lands. When my family subleased a school section, we were, as a leasees, we were responsible for doing all the fencing on it. And then, you know, then when that ranch sold and the lease went to somebody else, the landowner, the seller of the land, got reimbursed for those fences. You know, one thing I think, you know, my gut reaction, you know, the question, when's it need to be fenced? Well, before the new leasee turns livestock out, would be one place to start, you know, if it's possible, because of the problems, you know, the trespassing and the animals getting on other places. But you know, one thing I think it would do that if you have to have it fenced before you turn your livestock out on that leasee, the new leasee turns his livestock out, it puts the burden on the new leasee, not on the surrounding private landowners, you know, to keep your animals where they're supposed to be, which is, you know, part of Wyoming fence law. But it's, you know, the one thing it will do is if you're not going to fence it, shouldn't that be grounds, you know, if you're required to fence it, it's supposed to be fenced, you don't fence it. If I understood it right, it sounds like that's not grounds for vacating a lease. Maybe it should be, if you're not doing your due diligence. I think one thing it will do is these people that are trying to just go around, get state leases to rip off their neighbor, to be a pain in the south end, if they don't do it, you know, that's their responsibility. They need to do some due diligence, that you have to fence it before you can turn your livestock out. And we already have in state law, you have to utilize it. If you have a grazing permit, you have to utilize it for grazing. Hopefully not utilizing it for grazing, I guess that'd be a question for Mr. Crowder. If you're not using it for the purpose that you lease it, shouldn't that be a reason for vacating of the lease? I would think so. With that, Mr. Chair, and I guess one additional point, you know, we talk about the number of state leases. I think Representative Slagle brought this point up. Not all of them need to be fenced. Some of them, you know, how many, the question would be how many are already fenced, so this law wouldn't apply to them, and then how many would need to be fenced if a new sublease came in, and then it would be the responsibility of the leasee to fence them. With that, Mr. Chairman, I would take any questions you or the committee may have for me.
Questions, committee? Yes, Senator Hicks.
Mr. Chairman, Mr. Moline, so let me give you an example in my part of the world. Is we have these state sections and they're scattered out through in-common allotments. And so the way this bill's currently drafted, so if one permittee vacates that state lease, but another permittee that's already an in-common allotment out there picks it up, the way I read this, he'd have to fence that.
Mr. Chairman, Senator Hicks.
Well, he vacated it, so it was a vacant lease. Somebody in the same in-common allotment picks it up. The way this is currently drafted, they'd be obligated at their expense to go out. And here's the other thing inside of this, Mr. Chairman. So dealing with the Red Desert big chunk of Wyoming, low precip. So it's 80 acres per AUM. And a lot of the country out there, just like the Bighorn Basin. So that's 8 AMs per section per square mile. It costs today about $25,000 a mile. So you're talking $100,000 to fence a section for 8 AUMs. I don't know what the state rate is. So $6 an AUM, so $24 of grazing fees collected by the state. But under that scenario, if you fence 4 miles of fence to get around a state section at $25,000 a mile, that's $100,000 in fencing. You don't think that under this bill that Mr. Moline, that permittee, if they picked up that vacant lease, but they're in an uncommon allotment, but would be required to fence that?
Mr. Chairman, Senator Hicks, the way I read this bill, it wouldn't be an absolute that they would have to. That's the way I read it, but
And,
you're much more schooled on this than I am.
and if that's the way you're reading it, we don't have to, we can change the bill and modify it so that it works, hopefully works with other state lands. So if we choose to go forward, you have some idea, and I agree, there's no way you can get fencing state land on the Red Desert to work out at all. It's just with that kind of a cost, you'll never get interest off the investment even. So,
Mr. Chairman, if I may, Senator Hicks, I understand your point. That should be able to be fixed. If it's not, I agree, we need to delve into this deeper. I wholeheartedly agree with that. But we need to come up with something, and I know the danger of running something through too quickly and you don't take in account all the circumstances. I agree in your situation, no, that shouldn't be fenced. You're not really changing the circumstances. You're changing perhaps the leasee, but not the circumstances. Other places, you're changing the circumstances and the leasee, if that makes sense, Mr. Chairman, Senator.
okay. Thank you, Mr. Moline. Other public comment? Welcome back, Holly.
Good morning, Mr. Chairman, members of the committee. Perhaps this is entirely too simple, but I was just sitting back there contemplating, and my name is Holly Kennedy for the record. If simply striking the beginning language where it says, if livestock from privately owned adjacent lands stray onto state lands, and instead replacing that with when a state land lease changes hands, if you will. There's probably a better way to state that. I'll let the more legally minded people in the room decide. But if you just made this specific to when a state land lease changes from one lessee to the other, I'm questioning if that might eliminate a lot of the externalities that you're bumping up against.
Committee questions? That may help the bill, but I kind of agree with Senator Hicks. We've got a lot of work to do here and we need a lot of public comment. How quickly we solve what is a problem today might be more dependent on policy by the land board over what we can. I guess where I'm going with this is I don't know where we can stop with trying to fix specific problems that have been created. Go ahead, Representative Slagle.
I kind of missed what you were, this point you were stating. Could you restate that for me?
Yeah, absolutely. So the very beginning language states, if livestock from privately owned adjoining lands stray onto state lands, which seems to be part of the language that seems to be some of the most troublesome. I'm questioning if you replace that and say, when a state land lease is awarded to a new leasee, And then it would continue on to say, the Office of State Lands and Investments or the lessee shall be responsible to fence the affected state lands.
Mr. Chairman,
Good.
if I sell my ranch and my state lease under that language, then I'm obligated to probably have to fence that because we changed that state lease even though it was a voluntary contractual obligation. So you'd have to exempt that kind of transaction out, that it was a. and so-
Correct, and I think we can do that.
Yeah.
I think we can
We can,
exempt it.
and we start creating a laundry list of exemptions.
I know.
I'm just saying that, you know, on surface, it sounds like it might make sense. Potentially.
Okay, any other questions?
Awesome, thank you.
Okay, thank you. Any other public testimony? Okay, folks, what would we like to do with this bill?
Mr. Chairman, I move the bill and I have an amendment.
Okay. I'm sorry. Yeah, I don't see his very often. Let's start, okay, we'll start with you, Senator Larson. Go ahead and repeat what you said.
Mr. Chairman, I think we need a second. I don't know if you got one.
Oh, okay. Senator Larson, you moved the bill. Seconded by Slagle. And
Mr. Chairman, I have an amendment if I could.
go ahead.
Thank you, Mr. Chairman. On page 1, line 13, after the comma, delete that remaining line or portion. Delete line 1 and 2 on page 2. And then insert after the comma on page 1, line 13. And trespassing issues arise, comma, a fence will be built according to statute 1128-106 within 1 year. So the wording would read, if livestock from privately owned adjoining lands stray onto state lands and trespassing issues arise, a fence will be built according to statute 1128-106 within 1 year. Period.
Okay.
Don't know if I have a second or not.
All right, do you understand the amendment? We have a second to that. Seconded by Slagle. Discussion?
Mr. Chairman, I'd like to comment if I could.
Go ahead, Senator Larson.
I think this may help Senator Hicks's comments about the Red Desert. I don't know on BLM particularly, because it refers to privately owned lands, adjoining lands. So I don't know if that helps. I think it helps that it gives them a time frame. And I think the statute that is referred to would state that both parties share in the cost of a legal fence.
Okay, go ahead, Senator Hicks.
Mr. Chairman, so this is just a kind of an inquiry on the actual logistics of this. And so under that scenario, there would have to be a trespass before the fence would be constructed, as I understand it. So the state lands office would have to go out, issue a trespass notice. That triggers the fence. Is that correct, Senator Larson?
Sorry, I had my mic off. I do think that would have to occur. Otherwise, how would you know when one might be needed?
Well, I'm thinking that state land's not gonna be there. And I'm thinking that the trespass would be issued by one of the landowners, the landowner or the leasee of the state land. And once that occurs, you'd involve law enforcement and issues would arise.
Mr. Chairman,
Okay,
that could be the case. I would guess the state lands would probably call the sheriff, I guess. I don't know. That might be a question we need to ask the director.
okay.
Yeah, and Mr. Chairman, what I'm trying to get to is depending on the nature, the 1 year thing, it may or may not work. Depending on when that trespass occurred and when the final adjudication of the trespass. And it's just trying to actually work in the logistics of it. Is 1 year from, so I'm just asking, is it 1 year from the time of the trespass was either issued or adjudicated? What actually starts the clock? So there's a trespass. Is it just the notice of the permit? So if I have that state lease and I call the Office of State Lands and Investment and say, hey, my neighbor's trespassing out here, does that start the clock? Or is it after finding a fact and an adjudication by the Office of State Lands and then enforcement associated with that? So what starts that clock? Is it just notification or is it a final adjudication of a trespass?
I would prefer that it was actually investigated or whatever, that it did happen. I don't think a call would be enough.
Okay, so could we modify that amendment a little bit to say if the trespass occurs instead of issues, then it makes it kind of clear that we've gone through a trespass action. Am I okay on that? Anybody know? Representative Slagle?
Mr. Chairman, if that's an amendment to the amendment, I go with that. It's friendly.
Okay, go ahead, Alan.
Mr. Chairman,
Representative Slagle.
comment I would have on this is, I mean, you know, since I've been on this board for the past 2 years, we've had a lot of comments about State Lands Office and comments coming in and issues arising. So what I see is, I think Senator Larson's idea here is a good one. And then going back to Senator Hicks's deal, when does this start? Well, if we have a lessee on the state lands or the neighboring property owner, if either of them calls the state lands office and say, I have an issue with cattle trespassing, the state lands office should, if we do this right, should be required to say, okay, now we need a fence and it needs to be up within 1 year. And so it will most likely be in the springtime when people are turning out on their leases. It may not, because not always do we use our state leases in the spring, but a lot of times that's when people use these leases. It's the way I would see this, and I don't know if that sounds what you're thinking, Senator Larson, or not, but that's where my thoughts would be on this.
Okay, Representative Prego.
Thank you, Mr. Chairman. I have some language that we could use, but it probably does not fit within Senator Larson's current motion. And so we can either vote on that and then I can go through mine, might be the easiest way. We can, and if we like my proposed language better, we can use that. But it would essentially cover everything that everybody's talking about, I think.
Okay.
So, Mr. Chairman, before we get there, we got another issue if we're gonna start to amend this bill, but I want to point out to you, and anybody that's in the ranching business will understand this. So the way this is currently constructed, it says the adjoining private landowner. You're gonna deal with that. My point being is I've had livestock on me that were from 3 landowners over, because in the fall they start opening gates and they come through, and pretty soon It's not the adjoining guy. It's 2 ranches away, private lands as to where the livestock come from. And so I think, as Mr. Chairman, looks like Representative Crago is already on that.
Okay. Can you share a little bit of your idea first before we vote, so we have an idea how to vote on Senator Larson's motion?
Sure, Mr. Chairman. So on page 1, I would strike the words on line 12, privately owned. So it would say if livestock from adjoining lands. On page 2, on line 2, you would strike the words rather than the and the word private. And you would insert, and actually just to make it easier, you could, well, we'll stick with that. And then it would say upon written request of the adjoining landowner. So it would read the whole clause / sentence. If livestock from adjoining lands stray onto state lands, comma, the Office of State Lands and Investments or the lessee shall be responsible to fence the affected state lands upon written request of the adjoining landowner. So that would cover the situation that Senator Hicks is talking about, where we don't want to fence off the state land. And I think also what Mr. McGagnon was talking about, where you have state land leases out in the middle of common allotments. The common allotment doesn't want it fenced off. It wouldn't have to be fenced off only if they asked it to be fenced off. So if someone got it on a conflicting lease and the common allotment says we want it fenced off because that person's not part of our common allotment or is not going to join the grazing association, you could request it to be fenced off. And then to cover the other, which I'm not sure I necessarily agree with this, but for the purposes of today, I think to cover a lot of people's concerns about whether it's constructed 50-50 or all at the expense of the state land, I would also, and after the word landowner on line 2, the fence will be constructed according to Wyoming statute sections 1128-102 and 1128-106 within 1 year of the request by the adjoining landowner.
Okay. So now I think any further discussion we're on Senator Larson's motion to amend the bill. And I got a little out of process, I suppose, by listening to the other one, because I don't think it would have been fair to you, Senator Larson, if we'd have gone ahead knowing that we might have something that would work better. But at least we have an idea where we're going toward. Before we go any further, Senator Kolb, you had your hand up. Does it apply anymore?
No, I was
Okay.
attempting to lay the bill back, but I
Oh,
didn't get
okay.
recognized, so
All
here
right.
we are.
Mr. Chairman,
Yes, sir. Go ahead, Mr.
I
Larson, Senator Larson.
don't know if it's correct, proper to comment on Representative Crago's suggestion. I'm not sure. I hate to lose my amendment. I guess I worry about the adjoining landowner being the one that requests it, because I would say more than likely, it's going to be the leasee.
Yeah, it could be either. Okay, we may change it a little bit if we get into the second one, because there would be some additions. It could be committee. Are you ready to vote on the First Amendment? Are you clear on what it is? No. Okay.
Thank you, Mr.
Representative.
Chairman. I guess just in response to that last question, the lessee on the state lands could put up a fence no matter what. What we're dealing with here is state lands has taken the position that they are not a fence out. They're exempt from that particular provision in state law, which is 1126-102. in 106. And so they're saying that does not apply to them. So if I go in and I lease an in-holding in someone else's ranch, I can build a fence around that in-holding and I can make the surrounding landowner pay half. That's already in statute. What we're trying to figure out is the reverse. So I don't think it would be that this wouldn't apply to the lessee or the leaseholder because they don't need that. They already have the protection of state law, at least the way I understand it.
Thank you. Question being called. All those in favor of Senator Larson's amendment, say aye.
Aye.
Opposed?
No.
Okay, I would judge that the amendment failed. Representative Prego, why don't you repeat your ideas?
Thank you, Mr. Chairman. Page 1, line 12, strike the words privately owned. Page 2, line 2, strike rather than the and private, and insert upon written request of the adjoining landowner, which is our adjoining and landowner already in there. Following that sentence, the following sentence would read and be inserted: the fence will be constructed according to Wyoming statute sections 1128-102 and 1128-106 within 1 year of the request by the adjoining landowner. And I would move that amendment.
Okay, it's been moved by Representative Prego, seconded by Representative Slagle. Discussion on that amendment. Okay, we're ready to vote. All those in favor of the amendment, Anna, I better ask, you got it down? Okay. All those in favor of the amendment say aye.
Aye.
Opposed? Okay, I would say that amendment has passed. Further amendments? So, yes.
Thank you, Mr. Chairman.
Right.
There was some discussion earlier about making this bill effective immediately. I don't know if that's really critical at this stage, but I just wanted to throw it out there. I don't think it is, because this really doesn't fix the past problem that we discussed. So just wanted to bring it up. Thank you.
I think it would not take care of the past problems that we've got. And a problem that could create, well, we've got to get through the bill anyway, but we probably need more public comment and maybe more time to figure out where we are on it. It's a framework is really all it is, and a decision to go ahead with trying to solve a problem that's out there. I guess one of the things I would say before we move on, that address it? Okay. And everybody's okay with that? And it could be changed later on as we go along if it passes. So one of the things that another attorney brought up is there's no time frame. Does that within a year?
We've amended it within a year.
So that would take care of the time frame. Okey doke. I think. Okay. Any further amendments? All those in favor yeah. We don't have any more. All right. Roll call, please.
Mr. Chairman, this is a roll call vote for 25 LSO 0308, state lands fencing as amended. Senator French,
No.
Senator Hicks,
No.
Senator Ide, Senator Cold,
No.
Senator Larson,
Aye.
Representative Allemand,
No.
Representative Allred,
No.
Representative Banks,
No.
Representative Conrad,
No.
Representative Craigo,
Aye.
Representative Davis,
Aye.
Representative Slagle,
Aye.
Representative Winter.
Aye.
Co-Chairman Steinmetz,
No.
Chairman Eklund.
Aye.
That has failed sponsorship.
So that bill will not be taken up by the committee. Can be taken up individually if you want. Okay, next, so there's a little bit of a conversation. We're running into time restraints. Oh, I'm sorry. Okay, let's take a break. 5 minutes, yeah.
For them to have to pay tax on a state lease is what this one's about.
Okay. All right. The next bill for our consideration will be kind of backing up to, or is it? Okay.
Did you make this? It's this one right here.
All right. We're gonna be working on 25 LSO 0336, draft point 4. I think we will, Anna, did you want to make any comments on it? Go ahead and start, and then we'll go to our agencies.
Yes, Mr. Chairman, I can go over the bill really quick. It's actually a very simple bill, it's 2 pages long. It's entitled 25 LSO 336, Leased Agricultural Land Property Tax Exemption. So beginning on page 2, this bill draft indicates that property of the state of Wyoming owned and used primarily as land leased for an agricultural purpose is exempt from property taxation. And then the staff comment under the amendment indicates that the Joint Revenue Committee may also be taking this issue up at their final meeting in November, just for the committee's information. The committee may also wish to consider putting this tax exemption in its own paragraph rather than making it part of Wyoming Statute 3911-105A2, where it is now. And I would stand for any questions, but I'm sure that the Department of Revenue might also want to speak to this.
Okay. So could the Department of Revenue come on up and comment on the bill? Assessors included, if you'd like to.
Good morning, Mr. Chairman. Brenda Henson, Director of the Department of Revenue. I appreciate this opportunity to discuss a recent Supreme Court findings. That is the reason that we're here today. On October 9th, we received the Supreme Court decision, State of Wyoming versus the Uinta County Assessor. The issue on the appeal was a parking lot for a truck stop that is located in Uinta County. The land is leased from the state of Wyoming, and the court decided that land that is not used for a governmental purpose is not exempt, and the land, the parking lot, was deemed not a governmental purpose and therefore taxable. The decision goes on to discuss lands that are leased from the state of Wyoming that are not used for a governmental purpose, specifically grazing leases. And the question has been out there, quite honestly. Most of your county assessors, the Department of Revenue, everyone has noticed that there wasn't an exemption in statute for state leases, knowing that, as mentioned earlier this morning, for grazing leases, we're talking over 3.4 million acres that have not been assessed for property taxation historically. And this particular Supreme Court decision clearly states that anytime land owned by the state of Wyoming is used for something other than a governmental purpose, it should be taxed for property tax purposes, unless the legislature takes action to deem it exempt. So with that, we have been working, the Department of Revenue has been working with State Lands and Interim Director Crowder to identify all of the grazing leases statewide and use GIS to arrive at approximately what the estimated tax amount would be if those lands were taxed. This decision is as of October 9th, 2024. We assess property as it exists to the owner of record according to law on January 1 of each year. So this Supreme Court decision impacts January 1, 2025. So we knew that administratively, both the Department of Revenue and county assessors across the state had a job on their hands to identify all of these leases. The other provisions that we discussed with state lands, many times with leases, the language within the lease states that the lessee is responsible for any taxes, should there be any. But we've been made aware that on grazing leases, that language in the vast majority of them is not included in that lease. Now, for commercial type of operations, typically there is a provision for those taxes being paid, but not with grazing leases. So it should be noted that while this bill addresses grazing leases, those lands used for agricultural purpose, and agricultural purpose, as we've just verified, is defined in Title 39. Basically, anything that is used as cropland or grazing land that you derive an agricultural product, either crops or livestock from. So we have, we had over 10,000 individual leases that totaled over 3.4 million acres of land that we knew pursuant to this Supreme Court decision needed to be on the tax rolls for 2025. So I will tell you that we have been working with county assessors to see what that would look like with a very short turnaround time. But this particular statute, bill, if it were to pass, one of the questions that we would have, it does have an effective date of January 1, 2025. But the key will be, yes, that's retroactive, and yes, that can be done. We've had that done with property tax laws in the past. But how much time and effort do county assessors put into identifying, locating, and valuing these? Assessment schedules have to be out no later than the fourth Monday in April. So, you know, what guidance would they have related to that? I do believe that it's possible to value the property that the Supreme Court decision included in this for 2025, but it is going to be challenging. My legal counsel has indicated that this, bottom line, this is law as of the signing of this decision, and that as administrators of that law, we would have to value those properties and send out assessment schedules and tax bills for 2025, given the law right now. I'd be happy to answer any questions.
Questions, committee? Chairman Steinmetz.
Thank you, Mr. Chairman. Thank you, Brenda. Could we make this effective sooner? Would that be helpful? Could it be effective immediately upon passage and then save you some of that valuation work?
So, Mr. Chairman, Co-Chairman, so even if this bill were to pass, it's going to be that February, March time period. So effective immediately actually is further
It is.
than January 1.
That's right. I'm on 2025, excuse me. So that's right. Okay, thank you.
So, yes, Senator Kolb, I'm getting to you
Oh, thank you.
in time now.
I appreciate the
Thank you.
recognition, Chairman. Is there any way you could, and I'm just asking a question as not an attorney, put a stay on this with the courts until we have a chance to address it legislatively? Has anyone tried that? I just, as a question, because, and correct me if I'm wrong, it's the law. I mean, the Supreme Court has made a ruling. So then you have to assess, there's no question about that, unless you can somehow stay that order. It's gonna be, tell me if it's unavoidable, all the work you have to do to go through the process of putting out the preliminary, I guess, estimates on your tax. So we can't do anything with that. Could you please explain further how we can make a law ipso facto and go backwards in time, and that's okay? I mean, has it been done in the past, is my question. Thank you.
Mr. Chairman, Senator Kolb, for property taxation, we have had several examples where we go back to January 1 of the assessment year that is also the legislative session year. The most recent one we had was House Bill 45. That was a 4% cap for property tax purposes, and that was backdated to January 1, 2024, so that it could be implemented for the 2024 tax year. That is similar to what this bill attempts to do. Now, as far as your question related to a stay, our legal counsel at the AG's office did not mention anything about a stay, and I am not an attorney, so I definitely could not speak to what that process may look like. Again, it's a unique situation in that this particular case related to a specific parcel in Uintah County. And it's very clear that for that parcel, it becomes taxable for the tax year that was being appealed and for future. It's just the remainder of that decision that specifically spells out other types of land, that there specifically is not an exemption for the other types of land. So that's where I think it's a challenge for us to talk about staying this decision, when this decision specifically was to one parcel of land in Uintah County.
Follow up.
Yeah, thank you, Mr. Chairman. So legal counsel has gone through this and said that, in fact, even though it didn't address the entire state, it does address the entire state.
Mr. Chairman, Senator Kolb, if we looked on the decision, and I would encourage everyone, it's a short decision, it's 10 pages long, specific to the language related to the grazing leases. The decision states, the state contends that a holding by this court that the hospital property, that's confusing just because of what they call it, but it was a truck stop parking lot, is not exempt from taxation, will have broad implications for other lands managed by the Board of Land Commissioners. It asserts that the board leases millions of acres of state lands to private entities who conduct commercial businesses on the land. For example, grazing livestock by a private lessee is not a governmental purpose. It goes on further, and then the last statement is, whether such an exemption should be created is a policy question for the legislature, not this court. Under the plain language of Wyoming Statute 3911-105A-II, the exemption the state argues for does not exist. We defer to the legislature to create such an exemption if that is its will.
Okay. Yes, Senator Ide.
Not to waste a whole lot more time, but what was the contention that brought this Supreme Court case? What was the crux of the situation that, got it to, I assume the Wyoming Supreme Court is who made the decision, right? Thank you.
Mr. Chairman, Senator Ide, the case, it's State of Wyoming versus the Uintah County Assessor. The Uintah County Assessor was valuing a truck stop, and the parking lot for the truck stop was land leased from the state of Wyoming. She assessed that land and put it on the assessment rolls for 2024, I believe it was. And the state of Wyoming appealed that assessment, went through the normal process to the County Board of Equalization, State Board of Equalization, District Court, Supreme Court, challenging that that land should be exempt from taxation. The court found it was taxable as it was not a governmental purpose.
Yes, Representative Crago.
Thank you, Mr. Chairman. Director, just a quick question on other types of state property outside of grazing leases or surface. How many parcels of other state lands do we have out there? Or do we have an idea on top of all these state land parcels that our 23 assessors are gonna have to be assessing, are there a bunch of other parcels out there that we need to be paying attention to?
Mr. Chairman, Representative Craigo, I don't have a good number because some of our county assessors have mapped state-owned land. Now, not necessarily per lease, but state-owned land, just to have it identified for ownership. Other county assessors haven't mapped those lands in any way. And then we also have pursuant to the exemption statute, and if I can follow up on it. So that 3911-105 exemption states property of the state of Wyoming owned and used primarily for a governmental purpose. The following is not owned and used for a governmental purpose. And there are 4 of those. Improvements placed on state lands by lessees for private or commercial use. So you've got assessors that are valuing those improvements on state land currently to the lessee. The improvements furnished by the state to employees as a place of residence. Assessors are already valuing those. Improvements in equipment rented, leased, loaned, or furnished by the state to employees or groups of employees for the purposes of operating enterprises for which there is a service or admission charge. And then the last one is the entity or interest of the purchaser, his heirs, executors, and assignees in any land purchased from the state of Wyoming under contract for sale, the value thereof to be determined by taking the market value of the lands and deducting the amount of principal and accrued interest owed to the state of Wyoming on January 1 for each year for which the property is assessed. So we have some situations where we're valuing improvements and state lands. The information that we can glean from the statewide ownership polygon that we have available just doesn't tell us what types of leases those are. So unfortunately, that was a really long way of saying we have some information, but it doesn't answer your question.
Thank you, Mr. Chairman. I'm just trying to get to, I see the time crunch here is real. I mean, you have a very short time period to figure out not only all these state land leases, with grazing leases, which there's a bunch of, but I assume there's a few other types of leases out there regarding state lands that may or may not be currently being assessed. I don't know. This opinion obviously changes a lot, even though it's a gray area that you and all the assessors have been well aware of for quite some time. Now you have a definitive answer and you have to actually do something. I'm just curious if, obviously we want to deal with the ag issue here, but do we need to be doing something more regarding all these other types of state lands that may or not be subject to taxation moving forward? I mean, can we buy some time, buy you some time, buy our assessors some time until we're able to figure some of that out? Would that be helpful?
Mr. Chairman, I will say that since the statute specifically spoke to improvements as being not used for a governmental purpose, that the majority of the assessors have not assessed that land. And I believe that had they have been assessing the land under those other uses outside of that the state would have appealed those as well. I mean, that was the reason for the case in the first place. And so will the implementation or administration of this Supreme Court decision be perfect on year 1? I would imagine it's going to take a few years regardless, or to gather all the information and to get it as accurate as possible. I will say that state lands does have their leases mapped. We can use GIS to make this process a little less painful. With agricultural leases, we were going on the assumption, and we know what assumptions are, but we were going with the assumption that if it's land being leased for grazing purposes, that it was rangeland under Wyoming statute. Because otherwise, we would need to be getting an agricultural land affidavit from each of those operators and determining whether they met the 4 criteria for agricultural land classification. And we knew that that was impossible for 2025. Could it be done for 2026? Possibly. But the key is to the entire court decision is it mentions numerous times that it is the legislature's purview to grant any exemption. It's just that because this decision comes out in October and we've got an assessment date around the corner, that there's really, the possibility of a special session. I can honestly say, I am not a fan, not advocating in any way, shape, or form today for a special session. But if we could have a special session that eliminated the need to go through a great deal of work on one issue, that's a possibility. But other than that, unless we had a way of getting this bill through the session very quickly, it is a long session, so we are in session in January, so that's a possibility. The manner in which we anticipate rolling this out for county assessors across the state, and we've met with all of them, was to take the state lands polygon of all of the leases, overlay them over our productivity. We use agricultural land is valued based on its soils type. We would take the soils type, the productivity amounts, and then we would automate that process at the Department of Revenue. We could roll that out to all of the 23 county assessors in the state, but then the per acre value that would be utilized for those based on the soil type and class would be the value that's set by the county assessor, just like it is for the rest of their producers. We can automate that process, but that is using best available information, and we know that the assessors have much better idea of what's going on the ground than what we've got using this process. For 2025, we can roll it out. If push comes to shove, we can do it in that manner. But it's just going to be a quick turnaround. If we anticipated that it's going to be exempt in the end, but I am concerned, are we just talking about the grazing leases? Because I do think there's a much larger discussion here. The case that brought this forward was a parking lot leased from the state of Wyoming, used for a commercial purpose by a private entity. Is it the will of the legislature that that type of situation should continue to be exempt from property taxation? Or when that is not a governmental use, is it the will of the legislature that they should be paying property tax just like any other truck stop that has a parking lot? So I don't think it's as clear cut as some may deem.
Senator Ide.
I'll be quick, just one quick follow-up. So it was purely the improvement on that lawsuit, the value of that parking lot with the hospital.
Mr. Chairman, no, it was the land. So any improvements, meaning structures, any improvements to the land, the statute already clearly says that those are not a governmental use when it's leased by an entity for business purposes. So the assessor's been valuing those all along. It was the year that she decided to tax the land owned by the state that this case went to the Supreme Court.
Chairman Steinmetz.
Thank you, Mr. Chairman. Is there anything the governor can do to help? I mean, I realize executive orders are something we don't want very often, but just a stay until the legislature meets or anything, that avenue that could help you.
Mr. Chairman, Co-Chairman, I don't have that answer. It really has been a quick turnaround. This is October 9th that this decision came out. We've had a couple weeks to wrap our head around it, but I don't have the answer to that.
I don't know if anybody does, but you're welcome to come forward anytime to let us know, but I'm guessing not, or it's been discussed and the bill's been brought. Senator Kolb.
Thank you, Mr. Chairman. You've testified that you're not always accurate when it comes to the assessments, and it takes time to get caught up. Just how inaccurate do you have to be for it to be a problem? I mean, who monitors this inaccuracy, I guess, is my question. Obviously, who's gonna, I guess, who would be the ones ourselves, the state of Wyoming would monitor ourselves? I guess that's my general question I don't know the answer to, because it's already clear that we're not gonna be accurate. So just another follow-up question of just how inaccurate can we be without getting into trouble? Just a general question. Thank you, Mr. Chair.
Mr. Chairman, Senator Culp. So fortunately here, we're talking about grazing land. We're talking about rangeland. And the only information that we need, we have. So what we don't know is it really being used for grazing. That's the additional information that we would need to gather. Now, the other information on the other types of leases, that's going to have to be done at the local level. That will have to be county assessors that are getting that information. But they do have access to the lease agreements. I think that there's a significant amount of information there that can be. We do have imagery for some of the state that we don't even have to do on-site inspections. We can get a lot of the information in that manner. But always, the best source is the property owner. And the state of Wyoming is the property owner for these parcels. And so it's going to be definitely a joint effort between the Office of State Lands and county assessors and the Department of Revenue to make sure that those assessments are as accurate as possible.
Okay, thank you. Ms. Huxtable, you're on now. Tell us what you think.
Thank
of
you,
this
Mr. Chairman,
whole
members of the
plan.
committee. It's been a whirlwind from the time that this case came down, and as Director Henson said, the assessors did meet. We did have a meeting. We went through it with the Department of Revenue. We are trying to wrap our head on how we're going to do this. Please remember that in the statute, my job is to find and locate and value all taxable property. For years, anything owned by the state was deemed not taxable. We've went before legislative committees for the past, decade to talk about those exemptions in the statutes to try to get some clarification. Certainly the improvements, I'm going to use an example in my county where there's a cabin that's built on state land. That cabin is taxed. It's an improvement only, and it's already taxed per the statutes. But the state land itself, there's been questions in our minds for years whether it really was taxable if it's being leased. Because is that a governmental purpose? I'm going to be honest and tell you most county attorneys won't take that on for us. The fact that the Uinta County attorney supported her decision to do that is sort of a rarity because most of them don't want to take on the battle with the state. But it's happened, it's there, it's now been decided that that is not a governmental purpose. I went out to the state land website and tried to look at the leases in my county, specifically just Converse County. I apologize, Dixie Huxtable, Converse County Assessor. I don't know that I said that to begin with. I apologize. By my records, looking at that document as quickly as I could, which granted I didn't do a lot of research on it, I have about 808 active grazing leases in my county. I don't know if those people all qualify for ag status on their private land. I don't have time to do that between now and January 1st. We're going to go with the presumption. I don't like assumption. I'm going to use presumption that they are. But I also have solid mineral leases, and I have oil and gas leases in my county on state land. Fair enough that some of them overlap with the grazing. I don't know. This is something that we're going to have to figure out between now. And in my case, I try to mail sometime the first part of April. I don't have a lot of time to get this done. The lien date is January 1st. Please bear in mind, we have a few other exemptions going on in our office. We have a few hundred or thousand people coming to our counters for some long-term exemption relief that's taking a lot of our time. So it is a burden, and we're going to do our best to meet that burden. But in this bill, you're proposing to exempt the agricultural purpose. What about the other leases? That's a question that I have from Converse County. Am I going through this effort to handle my ag leases, which the department has tried to work out a way to push that out for me in a manner that I can value it and tax it, but what about the other leases in my county? How do I go find them? How do I track those? That's a big burden. So I guess what I'm saying is just be sure, one, if this is what we're gonna do, that we get this through fairly fast. We've all seen those bills that said, yep, we're gonna put those through really quick and make them retroactive to January 1st. They didn't quite happen that way. And so we are charged with now saying the state land that's leased is taxable. My job is now go find them, put them on, find a value, and then maybe in March, some of them will not be taxable if this bill were to pass. It's a conundrum for us. It really is. And I don't have the answers. I'm relying on you, the legislature, to give us some guidance on what your intentions are. We'll administer to the best of our ability what's in law. It may not be 100% accurate the first year. It may take a couple years to find all this stuff, but we'll do the best we can. We're just going to be in a short time frame to get it done. And with that, I would stand for any questions.
Questions, committee? Senator Hicks? No. Senator Ide?
You know, the question, thank you, Mr. Chairman. The outside uses outside of agriculture, Representative Craig brought that up, and I had that on my mind as well. Can you said you had how many 10,000 leases, Director Henson? Any speculation, maybe it was already brought up, on how many of those are non-agricultural? Thank you, Mr. Chairman.
Go ahead. Go ahead.
Mr. Chairman, Senator Ide, the 10,000 plus were the number of mapped leases for grazing leases. We have not delved into those other leases that are considered special use. We have been told that many of the special use leases may overlap with the grazing leases. We do know that if there are improvements on those special use leases, that county assessors have already assessed the improvements, so at least they have a starting point. So on their assessment schedule, it'll actually say improvements on, and then that assessment schedule is going to the lessee. The state of Wyoming hasn't been included in that discussion there because they don't own the leasehold improvements, if you will.
Okay. Representative Davis?
Thank you, Mr. Chairman. I guess in your opinion, will this hinder what the undertaking you guys have got to do right now? Or will this be a benefit to you if we do pass a piece of legislation like this without completely thinking this all the way through? I mean, you've got a course plotted right now. Will this hinder that?
Mr. Chairman, Representative Davis, uncertainty, I think we've all known that, at least we know, uncertainty is always a challenge. But I am not naive, and I believe that this is probably going to be a topic that the legislature will discuss, whether it's via this bill or some other piece of legislation. I recognize that. So I believe that in order for us to do our jobs, we have to assume that nothing will change for 2025 and that we have to move forward with the information that we have and complete it in that manner. If this comes in later, it may be a query. We can query information out of the Canvas system, and you'd query properties owned by the state of Wyoming that are agricultural use, and you change them from an active account to an exempt account. So, I mean, there are some benefits to having a statewide assisted mass appraisal system that we all utilize, and all assessors have those same tools. I can tell you in other states, they would be even pulling their hair out more because they don't have a unified system like Wyoming does. So we will do the best that we can to support the assessors. In the end, it's the county assessor's responsibility. These are locally assessed parcels. We, as the Department of Revenue, we try to give them tools to be as efficient as possible, but their name is on that assessment schedule and they have to defend it when it goes to court. So that's our process.
Okay. Senator, or, yeah, Chairman Steinmetz.
Thank you, Mr. Chairman. So just logistically, we're talking about how this is working in your office. Let's talk about the taxpayer now. So someone who has a state lease on agricultural land or some other special lease that you're talking about is going to get now a tax bill for their state leased land. Is that correct?
Mr. Chairman, Co-Chairman Steinmetz, yes, they'll be receiving a tax bill. Now, that's why we're working with state lands. As I mentioned before, most of the grazing leases currently in place don't have a provision that the lessee is responsible for those taxes. So it will be the state of Wyoming responsible for those taxes. And I believe we'll ask the legislature for funding. I will tell you that we were able to use GIS and the soils information. We were able to identify a fiscal note. And because it is rangeland, which, as you know, is significantly less in tax dollars per acre, the total tax bill statewide will be less than 3 million.
Okay, so then we would just be transferring 3 million from one pocket to, it would go from state lands to the Department of Revenue, or to the county assessors, excuse me. So it wouldn't go to our own department, it would go to the counties, is that correct?
So, Mr. Chairman, Co-Chairman Steinmetz, so it would be a tax bill, you'll get a value. The state of Wyoming will get a tax bill just like anything else. And remember, those tax dollars, even though you pay them to the county treasurers, 12 mils will go to the school foundation, 25 to the school district. Those taxes will be distributed just like any privately held land.
Okay, gotcha. That's all I wanted to know, just be very clear on that.
So the tax bill will go to state lands and then they'll attach that tax bill, I presume, on the lease? Or do we haven't figured that out yet?
Mr. Chairman, I believe that, and Interim Director Crowder could speak to this, but I do know that there's been some discussion about updating the language in the leases so that at some point, rather than the state of Wyoming possibly paying that property tax, the lessee would pay that property tax.
That'd be later.
That would be later because the current leases for grazing it's my understanding, don't have that language.
Okay. All right. Senator Kolb.
Thank you, Mr. Chairman. Maybe we can devise a tax rebate program for the state of Wyoming. But beyond that, a question to the assessors. What is there any estimates in the cost that you incur by trying to deal with this change and how you have to assess? I mean, as an association, do you have any numbers, or could you get some numbers? Thank you, Mr. Chair.
Mr. Chairman, Senator Cobb, at this particular point, no, we do not have an estimate, but there is certainly going to be a cost, and I'm going to use my county as an example. We have a contract GIS person, so we will be paying that person an hourly rate to go through and look at our parcels, look at the state leases. As I said, we have other types of leases besides grazing, so we're going to have to, even if this bill should pass, those other types of leases are going to be taxable. at least in my opinion now, based on the court case. So the mineral leases, solid minerals, the special use leases, we're gonna have to identify them, get them into our system to value them. GIS is gonna be my best tool to do that, with the help of the State Land Board. So there will be a cost. I do not have an idea. The assessors are talking about this daily on a group chat about this. So we have a meeting in January and we hope to be able to come up with some estimate of those costs that we could certainly share. But yes, there will be some substantial costs to the counties to get these on the tax roll.
Okay, further questions? Okay, thank you. Other testimony? Come on up, Mr. Crowder. So, well, we're gonna power on through lunch and finish this before we're done. So I'm hoping that everybody will get hungry enough that they quit talking maybe. But anyway, I'm guessing we all have enough storage. We may just keep talking, but go ahead.
Thank you, Mr. Chairman. Jason Crowder, Interim Director for the Office of State Lands and Investments. I thank Director Henson. She really relayed everything that I was going to relay for you. So what I can provide to the committee now is what we are doing after the decision and with the input of the Board of Land Commissioners, what we're doing going forward. As she indicated, the estimate of the first tax bill is just under $3 million if you assess everything as rangeland. So we are working with the budget department to add that $3 million to our supplemental budget request to make that payment. Because that, as she mentioned, the grazing and agricultural lease doesn't have a provision where the lessee is responsible for any taxes. And so it's appropriate that the state be responsible for that. And so we're going to ask the legislature to make that payment. To that end, though, the Board of Land Commissioners has asked that we present them with emergency rules at their December meeting that would insert a provision into the grazing and agricultural lease for any leases renewing and going forward, that provision be added, that the taxes be the responsibility of the lessee for whatever use they're conducting out there. And as Assessor Huxtable mentioned, not all of them fit all four criteria to be ag exempt. Some have horse operations that don't meet all of the exemptions. And so it's appropriate that we understand what that is. And if they don't meet the exemption, that possibly the Board of Land Commissioners will pass that tax bill on. So we'll provide emergency rules for them to that end. And again, as they mentioned, this is a really new situation. This is a really new world. And so we're all just trying to understand it. And one of the reactions is, how do we create a scenario in our leasing documents that's consistent and fair? And this is the first thing for the Board of Land Commissioners to consider. Again, it's emergency rules. It's a step in the direction. It's not this is how it will be going forward, but it's the first step for the Board of Land Commissioners to take for that. We are going to have to do an assessment of not only our grazing and agricultural leases, but all of our commercial leases, as Director Henson mentioned. Some of them do have a pass-through provision, but not all of them. So we do need to go into each and every single one, and there's anywhere from 1,600 to 3,000 that need some type of review to see what situation they're in and if we need to put that provision in those leases as well. So we will begin that undertaking. Also, we've not had to worry about this in the past, as they've mentioned. So our GIS is accurate to the point that we need it to be accurate. It wasn't accurate to the point of assessing taxes. So we are going through an effort right now to review all of our GIS information, see if we can find low-hanging fruit to make that more accurate for the assessor's use going forward. But that's going to be a lift that we're taking on leading up to the January 1st, 2025 date. I think the only other thing that I would offer the committee is just because state lands are not taxed right now doesn't mean that funding isn't going to the specific uses those property taxes are intended for. And obviously every county has different uses those monies are for, and they are at different rates. So we'll need to understand all of that. But obviously, we're providing money already for schools. That's one of our largest charges, right? We provide money for weed and pest, work on state lands, and many others. And I don't know the whole list. Obviously, this is not something that we pay attention to or haven't in the past, but we are in other mechanisms. The state is providing funding to the counties for the uses that the property taxes are intended to address. To what level, we don't know, and we're going to do that assessment as well as we go forward. But again, thanks to Director Henson for carrying most of my water. Happy to answer any more questions.
Okay, questions, committee? Okay, thank you. Further testimony? Got a couple more here. Come on up, gentlemen. Absolutely.
Good morning, Mr. Chairman, members of the committee. I'm Jeremiah Reeman here on behalf of the County Commissioners Association, and I'll just start out by saying I'm on the tip of my skis being up here. This is really fresh for us as well as it is for you, so we haven't established a position on this issue yet. But what I think I would recommend to the commissioners and what I think I'm going to recommend to you all today is that we perhaps consider a larger moratorium, an exemption in statute that has a sunset. I ultimately think we need to have a sunset in there, but give us some time to sit down and maybe you can help us craft a group that should be part of this effort. But let us sit down between the counties, the state land board, the Department of Revenue, others, and see if we can't come back to you with a recommendation on how to work through this. As you've heard, there are going to be cost issues for the counties. There are going to be costs, obviously, for lessees, whether they're agricultural or some other lessee on state land. So give us some time to look at this, and I think we could get something through the legislature fairly quick with your help. And be able to then do that work during the next interim. So we're not trying to rush and trip over ourselves coming into this session. So that's just my simple recommendation, what I think I would ultimately recommend to the county commissioners. And with that, I'd be happy to discuss any questions.
Questions? So you're suggesting that we forget about this January 1st, 2025 date, or we go ahead and power through with the bill as best we can, and then we start working on the details of the bill later on? I'm not sure I'm clear on that.
Yeah, appreciate the opportunity to clarify that, Mr. Chairman. I guess what I'm suggesting is you absolutely want to have that January 1, 2025 date in there, because that's ultimately when the assessments are going to take place, right? So we want to have that in place. What I guess I'm suggesting is that we don't go into this particular part of statute. We perhaps put another exemption in the law that says, state lands. I'm not going to be able to come up with it, but we could work with the attorneys. But it's going to be for all of the various activities that are happening on state lands. Sunset that, give us a year, give us 2 years to work through that, whatever that time frame is, and let us go to work and then come back to you with a recommendation that says, these should be taxable, these shouldn't be taxable. And this is how we can do it.
Okay, all right. Any questions, committee? Thank you, sir. Mr. Moline.
Thank you, Mr. Chairman. Brett Moline, Wyoming Farm Bureau Federation. I'd like to see this bill go forward. I also agree with Mr. Ryman that we need to take a larger look at it, but to get this, to keep this issue going forward from the Ag Committee, I think is important. And this might be a question more for the assessors and for the Department of Revenue, but what question I have about the January 1st, 2025 date. And maybe I'm just seeing black helicopters, but if that's when the date is for what type a property that you assess, do we need to have this effective December 31st, 2024? So that on January 1st, it is clear that it's not taxable. I don't know which date would come first. I don't know if it makes any difference, but yeah, I do have to say, we looked at this topic a few years ago. I think Department of Revenue looked at it for 2 years, and there was nothing went forward to make any changes. And so I do think we need to take a deep dive into it, but I would like to see this bill go forward to make sure that the ag land leased out by the state is tax exempt. With that, Mr. Chairman, I would sit for any questions.
Okay, any questions? Thank you. Mr. McGagna.
Thank you, Mr. Chairman. Jim McGagnon, Wyoming Stockbrokers Association. We too believe it's important to move this bill forward, not because we think it's the final answer or the best answer, but it provides a protection that we need in case other initiatives, such as were suggested by Mr. Ryman, or that do not move forward. We're going to be focusing our attention right now at looking at the interim director of state lands mentioned a rule change that would enable them to, at least in lease renewals, to pass these costs on to the lessee. We want to do a lot more study as to whether, in fact, the board has currently the authority under statute to pass on a cost like this. I think that's the first question. The other issue that arises, they will be renewing hundreds of state leases beginning in January. And I believe that it's premature for them to, if they do have the authority to do it, to build that into leases that are renewing in the next 2 or 3 months before we see the outcome of this legislation, because that would be carrying forward there. And finally, my last thing, just a minor suggested edit to the language on page 2, line 3. It says land leased for an agricultural purpose. The state land office often on a short-term basis issues temporary use permits for grazing of agricultural land while land is vacant. And simply so we don't go back and forth would be to add after leased or permitted. So that if land becomes vacant and is permitted for a year or two or under a temporary use lease, that it wouldn't suddenly have to be taxed and then changed again. So with that, Mr. Chairman, I'd be happy to answer any questions.
Questions, committee? Thank you. Is there any further testimony on this bill? Committee, what's your pleasure? Been moved by Representative Conrad, seconded over here by Senator Kolb. Discussion on the bill? Yes, sir.
Is it time where you would be entertaining amendments or just having discussion?
Well, that's part of it. Amendments, yes.
Yeah, so, Mr. Chairman, I had our staff sent everybody out a copy of the Supreme Court ruling in there, and one of the things that just strikes me as maybe a glaring omission is that wasn't even discussed, is when you look at 3911-105 and it talks about exemptions. And so the courts focused it, and I think the state did, on Romanet number 2, which is property the state owned and used primarily for governmental purposes. But if you go up and read the statutes in an entirety, there's a provision there under A, Romanet I, section E. And this is lands entered under any act of Congress when final proof of ownership has been issued by February 1st, whether patent or not. So these are our institutional lands. These are your school trust lands, the university lands, the penitentiary lands, all of those. I don't know why that wasn't brought up, but clearly it looks to me as we've exempted all of those lands that we acquired from the federal government as part of our act of admissions. You don't read it that way? So anyway, so whether we can debate that, but if we wanted to broaden this out, Mr. Chairman, we could do that. And we could just go in there and say that land of the state of Wyoming acquired under Article 18, Section 1 of the Wyoming Constitution is exempt from property tax. That's the land. It's not the improvements. The improvements is a whole different thing. To get back to that issue, if we were inclined to broaden that. So I would be curious, as a little bit of discussion as to why A Romanet I subsection E is not the same lands. So.
Representative Prego.
Thank you, Mr. Chairman. Well, because little I says property owned by the United States, not property owned by the state. And
But back to my premise, if we wanted to just say, look, any of these lands acquired, active admission, we could very simply make this bill and say land of the state of Wyoming acquired under Article 8, Section 1 of the Wyoming Constitution is exempt for the purposes of property tax, period.
Representative Prego.
thank you, Mr. Chairman. And I don't have my constitution sitting here in front of me, but in 19, if you go to the exemption, if you go to the exemption statute, if you go to the constitutional provision regarding taxation of state property in 1956, I'm getting hand signals from about here. It specifically was, it was amended to include, to change it, because originally all state property was exempt. And then at some point, the citizens decided to amend the Constitution and limit it to only property used for a governmental purpose. And so that's why we're sort of in this pickle today.
Well, except for the last wording in that amendment. So that's section 15, or Article 15, section 12. So you're right, it says right up there, it shall be exempt from taxation and other such properties as the legislature may by general law provide. And so that constitutional amendment under Article 15, section 12 says we can exempt, the legislature can exempt, may exempt by general law, provide any exemptions. And so back to, if we just adopted this, certainly under that constitutional provision, we have the authority to do that. But my preference would just be say any of those lands acquired under our active admission in Article 18, Section 1 of the Constitution. So that's your university lands, your land grant or ag experiment station lands, your university lands, all school trust lands, the miner's home, all of those lands that were granted through some act of Congress would be exempted from tax, not the improvements on them, just the land.
Thank you, Mr. Chairman. And just a question, I guess, for Senator Hicks. What about lands acquired otherwise by the state, whether through tax sales or, I mean, there's lots of state lands that go way back, turn of the century type stuff that were not active admission lands, or those, how do we exempt those?
Well, if they're used for governmental purposes, they're exempted under Romanet 2. If they're not, so let's use the example of Wyoming Game and Fish Department has acquired, in some cases, state parks. I mean, all of our state parks are not institutional lands or land grants from the federal government. But the very nature that the state is operating those lands are government for governmental purposes, further submission of the state of Wyoming or the agency. So if a Game and Fish acquires private lands and they're managing it as a habitat unit because they are just a fiduciary to manage the wildlife of the state of Wyoming, I see that's a governmental purpose. Would say the same thing with state parks. The little tiny exception that may not capture would be those state lands that we acquired. We purchased those. And then there's some commercial lease or some improvements on them. Those, but you could include that language, any other lands acquired by the state. So I just tell you, this is very narrowly to ag. This is the ag committee, that's appropriate, but we're not limited by just focusing strictly on agricultural purposes. I think we'd garner a lot more support if we just exempted all of those lands owned by the state of Wyoming. That's for discussion, Mr. Chairman.
Okay, so a question I'd have for you, then what do we do about that parking lot in Uena County that the court says can't be exempted from taxes?
I don't know this is fact. Those are state hospital lands, and those lands would have been conveyed to the state for the purposes of a state hospital. So those are institutional lands as part of those federal land grants. And so now that, whether that parcel was purchased from private property, I don't know the nature of the title on that. But had that been part of the original land grant for those institutional lands, which state hospital is one of them, it would have exempted those out. Or, getting back to Representative Crago's thing, we can just add a language, or any other lands acquired by the state of Wyoming, period. So either those land grants and any other lands acquired by the state of Wyoming. You could add that language in the fact, but my guess is because it does say hospital lands, that those were part of the lands granted as part of the act of admission. Mr. Chairman, I think you got a question down there.
Representative Crago.
Thank you, Mr. Chairman, and maybe we're trying to go to the same place. I mean, I sort of like the idea that Jeremiah had about creating some sort of moratorium or just 100% exemption for all land owned by the state of Wyoming until we can figure out what should be taxed and what shouldn't. That buys us 2 years. It's gonna have to be for a 2-year moratorium because of the deadline.
Yeah.
Otherwise, we just stick our assessors in the same spot that we're in right now. So we do a 2-year exemption. We just craft a bill that says all lands owned by the state of Wyoming are exempt from property taxation until, December 31st, 2026. That would be an option to get us through this, give us time to work on it.
Senator Ide.
Thank you, Mr. Chairman. Would it be, it's just a thought, should we be thinking about repealing this 1956 amendment to the Constitution along with the legislation that we're running right now? Because that would get us back to where we needed to be and not have to pick and choose what uses are going to be taxed on state lands. So just a thought. Thank you.
Senator Kolb.
Thank you, Mr. Chairman. I'd propose an amendment to add a sunset date, and we can discuss this at July 1 of 2027. That'll put us into a budget year, and that may be more appropriate for a discussion for a finalized position on where we want to be and give us some time. Thank you, Mr. Chairman.
I'm sorry, was that July 1 or January 1?
July 1.
July 1, thank you.
Make that 2027.
So is that a motion?
Yes.
Okay, it's a motion by Kolb. Is there a second? Nope. Okay, just.
Madam Chair, Mr. Chairman, I don't know that we have a motion on the table. I think we just have discussion.
Okay. I thought
I don't know that anybody's made a
Has
motion.
anybody
so-
moved the bill?
and if-
I thought we did.
Yes, the bill is.
He's at an
Okay, so we're
effective date,
discussing.
a motion that does.
You just amended the effective date.
Okay.
Okay,
But there was no second, so that.
on this bill, you meant, okay.
All right. But we're discussing other possibilities besides this bill. Go ahead, Representative Craig.
All right, Mr. Chairman, I'm gonna propose an amendment. And my amendment would be as follows. We're gonna create, it's pursuant to the staff comment, we'll put it in its own paragraph at the end of the exemptions in 105. 3911 105, we'd create a new exemption under subsection A. And I don't know the Roman numerals, it's because we added a bunch last year. So there's several new ones in there, but at the end of those, we'd create a new exemption for all property owned by the state of Wyoming, and it would have a repealer, or it'd have a sunset date of December 31st, 2026. And the reason we can't do it in the middle of the year, Senator Kolb, is because that's not, our taxes are assessed either on January 1, and so it has to be the end of a calendar year. That's why we can't have the sunset in the middle of the year. But I mean, we could do it at the end of 2027. I'm just saying 2026 should buy us enough time.
where did you put that? So we're under Romanet,
So
3911-105, Romanet 2.
Yep, it actually would not be Romanet 2, it'd be A Romanet, and it's gonna be after the 2 we added last year regarding residential property taxes. And the reason I'm doing that is because to put this sunset in there, that I don't want to tie it to any other provision within the exemptions, and it would only apply for 2 years until we were able to figure this out. And if we get it figured out quicker, we can repeal it quicker. If for some reason we're able to do it by the end of session in this coming spring,
So you're creating a new Romanet 2.
I am creating a new exemption, not under 2. It would be, 2 would still exist. We're not touching that. We would just go on top of it down further, which is gonna be, I don't know my Roman numerals very good.
It would be a new 46.
Thank you.
I didn't hear that, Anna. Where would,
It would be a new paragraph 46, I believe. If I'm reading this right. Anyway, I get the gist of it. I'll be able to figure it out.
so she's going on.
So,
Second,
Been moved and seconded. I'm not sure I understand where it goes in the statute, except I trust that we,
it would create a new
yeah,
3911-10,
okay.
whatever.
We'll have time to work on this later if we don't quite get it right, so, are we ready to vote, committee? Go ahead, Senator Ide.
Thank you, Mr. Chair. Back to the Constitution 1512 and the amendment that was made in 56 that Representative Crago brought up. Would this statute conflict with that amendment to the Constitution? Just a question. Thank you.
Did you see that, Bob?
You know the answer?
Thank you, Mr. Chairman. Senator Ide, I suppose someone could make that argument. I mean, but they could make that argument about any exemptions. It says what it says. It says we can provide exemptions to any type of property as long as it's generally applied. This is generally applied. And I think Senator Larson has his hand up.
Dan, I keep missing you. Go ahead, Senator Larson.
Thank you, Mr. Chairman. So are we still needing what we have up there on the agricultural purposes?
So Madam, or Mr. Chairman,
Yep, go ahead.
so I think Senator Larson, all that language goes away. And so the text of the bill now is just gonna be, any lands owned by the state of Wyoming would be exempt for the purposes of property tax, period, right? And then the section 2 would have a sunset date in there of July 1st, 2027.
Thank you.
December 31st,
Yeah, December.
2026.
Whatever.
December.
Like-
So let's change that to December. Everybody get that?
So could we talk about that? Just the logistics, and I'd like
Yeah.
the Department of Revenue and the clerks to weigh in on this. And so that presumes that, I think under that sunset date, that this legislative session, we would find some type of fix. That wouldn't go into effect until July 1st or effective immediate, but 2025.
Okay, go ahead.
It actually buys us 2 sessions. It would buy us this session and the one in 2026 to deal with it. And then,
So December of 2026.
that's right, yep, December 31st, 2026. So we would have 2 years, 2 sessions, and we'd have and essentially we buy ourselves an interim to discuss this and get it through the appropriate committees or working groups or whatever. I think that's how it would have to work. I mean, and we could always extend it. If it looks like we're not gonna get there, we can extend it another year, but we should be able to do it in 2 years.
Remember, Mr. Chairman, we are the legislature.
I know, we can do anything we want. Sure, so.
Not saying that's good or bad, I'm just making an observation.
Does the Revenue Department have anything to say about this idea? Do you think it's logistically okay to approach it this way? I'm sorry, Brenda, put you on, or Ms. Henson, but I'd like to have your idea. It changes the bill quite a little bit.
Mr. Chairman, I do believe that providing an exemption for all lands owned by the state of Wyoming is easier to administer. It is representative of what has been done historically. And when we started talking about how the state of Wyoming acquired the lands, that was going to be some homework for the county assessors. So I do think that the suggested language is cleaner. I do appreciate that the bill would be effective January 1, 2025. And if you articulate that this basically has the taxability of those state lands be treated just as they have been historically, and that we're just buying 2 years to comply with the Supreme Court's decision. I mean, what I'm hearing is it's possible that in 2 years, the same exemption that exempts all property owned by the state of Wyoming would continue on. That's still an option. I think that the legislature has that ability to either grant or not provide for an exemption. I think it will be a much more robust discussion than some may think, because I believe that there are a lot of constituents in the state that believe that when government goes down the road of private sector, that's not a governmental use, and it should be treated just like those other properties that are privately held. And the constitutional language that talks about used for a governmental use, keep in mind that that's not limited to the state of Wyoming. That's for all governmental entities. And the Constitution changed. All governmental entity property used to be exempt, and then the citizens of the state changed the Constitution to say when used for a governmental purpose. We've been trying to define what is a governmental purpose for a very long time. So I think that there is a little bit of a sticky wicket there in that our Constitution talks about governmentally owned property when used for a governmental purpose and any other exemptions that the legislature deems appropriate. I don't know how that would pan out in court because I'm not an attorney. But if the Constitution says it has to be used for a governmental purpose, if it's owned by the government, I'm not sure that the end of that sentence really relates that to this legislature. I don't think it meant that you can ignore that for a governmental owned property, that it's used for a governmental purpose, and simply make an exemption. I don't think that that was the intent. But that will be something that will be discussed during these interim discussions.
Okay, any further questions? Thank you.
Thank you.
Coming back. All right, any more discussion or amendments to this bill? No. Okay, I think we're ready to vote. Now, wait a minute. Now, question on the amendment. Better, yes. Better get done with that one first. Okay, all those in favor of the amendment, say aye.
Aye.
Opposed? Okay, the amendment passes. Now, any further amendments? Okay, we're ready to vote.
Mr. Chairman, this is roll call for 25 LSO 0336, leased agriculture land property tax exemption as amended. Senator French?
Aye.
Senator Hicks?
Aye.
Senator Ide?
Aye.
Senator Kolb?
Aye.
Senator Larson?
Aye.
Representative Allemand?
Aye.
Representative Allred?
Aye.
Representative Banks,
Aye.
Representative Conrad,
Aye.
Representative Craigo. Representative Davis,
Aye.
Representative Slagle,
Aye.
Representative Winter. Co-Chairman Steinmetz,
Aye.
Chairman Eklund.
Aye.
15 aye.
Okay. That bill passes. I guess a question before we move on, the task force or the working group. We're gonna do that later, I presume? All right, there's been some suggestions from the public on how that might work, but, okay. Let's move on to the next bill, which is a fairly interesting but odd one, or an odd concept, I guess. I'm not sure I quite get it. But, Anna, you want to discuss the,
Mr. Chairman.
Yes.
Clayton take us through the overview.
oh, go through that first? Sure. Clayton, you want to take us through the overview? Thank you, everybody. When you're ready, go ahead.
Mr. Chairman, members of the committee, I have provided for the committee a fact sheet that briefly describes a proposed rule regarding natural asset companies. And it also describes the Sustains Act. And today I will briefly summarize the contents of that fact sheet, and then I can stand for any questions. So natural asset companies are a proposed type of public for-profit corporation that would maintain and grow natural assets and also cultivate the associated ecosystem services. And an ecosystem service is essentially a benefit that is provided by an ecosystem. For example, clean air or clean water, productive soils that in turn might be used by, say, a farmer or a rancher. A natural asset company would be required to maximize ecological productivity, and it would also be required to engage in revenue-seeking operations that do not conflict with that primary goal of maximizing ecological productivity. A natural asset company would also be able to engage in revenue seeking regarding ecosystem services which have markets, for example, selling carbon credits. In 2023, the New York Stock Exchange proposed a rule allowing natural asset companies to be posted on the New York Stock Exchange and to issue shares. The proposed rule also included a number of regulatory and reporting requirements that natural asset companies would need to abide by. In January of this year, the New York Stock Exchange withdrew the proposed rule. Speaking on the Sustains Act, the Sustains Act was passed in 2023, and it expanded the USDA's existing ability to allocate non-federal funds to existing conservation programs. The act also allows the USDA to provide matching funds for any of those non-federal funds that are provided. Additionally, it allows financial contributors of those non-federal funds to require certain conditions for how those funds might be spent. Specifically, it allows them to specify the intended conservation program, the intended natural resource concern, or the intended geographic area to which those funds must be allocated. Additionally, there's also a provision regarding ecosystem services benefits. The provision states that if ecosystem services benefits might be sold in an ecosystem services market, that the financial contributor of those associated funds can make themselves entitled to their share of the ecosystem services. That's a brief summary of the contents of the fact sheet. I can stand for any questions.
Questions, committee? Okay, oh, we've got one. Go ahead, Senator Ide.
Sorry, thank you, Mr. Chairman. How do you define non-federal funds? Heard that word a lot. Is that just private funds? Thank you.
Mr. Chairman, Senator Ide, it would be really any source that is not a federal source. So it could include private sources, and from my research, that tends to be the most common cited source, but it could in theory also be a state source.
All right. Any other questions? Thank you. Anna, would you like to go through the bill for us?
Thank you, Mr. Chairman. This bill draft is entitled 25 LSO 309, Protect Wyoming's Lands Act. The bill draft creates its own chapter entitled Natural Asset Companies. And so beginning on page 2, a definition of natural asset companies provided. It is defined as a company that holds a conservation easement in Wyoming or has the rights to the ecological performance of a defined land area in Wyoming. It has the authority to manage such area for conservation, restoration, or sustainable management, and its primary purpose is to manage, maintain, restore, and grow the value of natural assets, or create or carry out activities that do not cause any material adverse impact on the condition of a natural asset in the area and replenish the natural resources used in the area. Subsection B on page 3 states that it shall be unlawful for a natural asset company having a conservation easement or defined land area entirely within Wyoming to sell its credits through a national securities exchange. This subsection shall not prohibit a natural asset company from selling its credits if it has holdings outside of the state. Subsection 2 states that this act shall apply to natural asset companies with conservation easements or defined land areas entirely within Wyoming on or after the effective date of the act. And section 3 provides an immediate effective date. And I would stand for any questions.
Questions, committee? Yeah, go ahead, Chairman Steinmetz.
Thank you, Mr. Chairman. Could you go over page 3, line 8 through 10? This section shall not prohibit a natural asset company from selling its credits if it has holdings outside the state of Wyoming. Is that regarding land outside of the state and the company is within the state, or exactly what does that mean?
That would entail a natural asset company that would have holdings within Wyoming and another state. If it had holdings, say, within Montana and Wyoming. So if it wanted to sell its credits on a national stock exchange, it could do so if it had holdings in more than one state. And it would be a policy question for you if you wanted to change that.
So that might be a little bit of a loophole.
It could be a loophole, yes. But then again, I mean, the Wyoming legislature wouldn't have a whole lot of authority over what it did with its holdings outside of the state. So.
Thank you, Anna.
Oh, we got one.
Mr. Chairman,
Yeah, go ahead, Senator Hicks.
can somebody describe to me the nexus between conservation easements and a natural asset company? If I don't get that. What's the nexus?
I could take that.
Oh, okay, Chairman Steinmetz.
Thank you, Mr. Chairman. That is one of the proposals that a protection for a conservation easement owner, because one of the concerns is that without permission for the conservation easement, that those natural assets will be sold off on the New York Stock Exchange without the actual property owner's permission.
I'm still trying to understand how the easement affects that ability.
It's just a coverage for the easement holder so that the people coming in on the stock exchange can't just come in on top of an easement without the property owner's permission.
So I'm just trying to understand how that would practically work, since I have an organization here that, you know, through the Wyoming Stock Growers Land Trust and a number of other ones around the state of Wyoming that hold a lot of conservation easements, and how somebody would come in and buy something, a natural asset, because that land still belongs to the private landowner. The easement's held for specific purposes that may have nothing to do, it's open space. And so I'm familiar with like like stock growers, any normal agricultural activity that's conducted on those lands can continue forward. And so how would this then allow some company to come in there? Because it's really not a company, it's gonna be a private landowner. And the land could be held by a company or family corporation or an S corp or an LLC or something. They would be the ones that would have to sell that natural asset. The way I understand how this works on the stock exchange, which I think the SEC has precluded those from happening, at least for right now. I still trying to understand the nexus of how an easement affects the ability. I don't have to have an easement and I could go and roll my land as a natural asset. And market those carbon credits. I've got a number of landowners in my district that have explored those opportunities to market carbon credits as one just based on their normal grazing operation, and their lands are not held in a conservation easement. And so I'm just trying to understand why we carved out only those lands that would have a conservation easement on them. That's what I don't understand.
Go ahead. Anna, you got the answer for us, maybe. Go ahead.
And maybe Clayton could add to this as well, but in order for a natural asset company to have any holdings in a conservation easement, they'd have to have permission from the landowner. So from what we understand from Clayton's research and otherwise.
And Madam Chairman, I think that is right. What I'm saying is you don't have to have a conservation easement. You could still market your natural assets. So if the goal is to stop natural asset companies from acquiring those, let's call them ecosystem services or amenities that the land provides, and then selling those on the market, you don't have to have a conservation easement to be able to do that, because that's a private transaction between a landowner and a contractual that I'm going to provide you X and you're purchasing Y. Again, I don't understand the nexus of having to have it only specific to conservation. Madam, or Mr. Chairman,
You have something to add? Representative Craigle.
I was just gonna note, following up on Senator Hicks' comment, that I actually think the way this is drafted, that a private landowner is a natural asset company.
well, that's the way I read it.
And so that they would not be able to market their own carbon credits, whether through stock exchange or otherwise. I mean, if you look at it, it says a natural asset company, and then it has two things. One is holds a conservation easement in Wyoming, or has the rights to the ecological performance. Well, every rancher has the right to their own ecological performance on their particular land. And so I think it encapsulates both of those, whether it's a company off in New York City doing it or our local ranchers, the way it's drafted. But that's just my thought on it.
Okay, further discussion? Yes. Senator Cole.
Thank you, Mr. Chairman. Just a question about the other states that have a bill, this similar law. I mean, where did this come from? What we just come up with this, or did we model it after something? Thank you.
This was, I'm sorry, Chairman Eklund, Senator Cole, this was based off of Representative Hagman's legislation.
Yeah, so I think it came up, go ahead, Senator, you know.
Thank you, Mr.
Chairman
Chairman.
Steinmetz.
It was based off of Alan Slagle's concept, Representative Slagle's bill last year, and then the one that's in Congress now. So that's where it came from, and the language is nearly similar. So it's to protect both private land from these things being sold on the New York Stock Exchange. So some of the issue comes from the fact that the World Economic Forum has a way of accounting for natural assets that basically they sell credits for without the landowner's cooperation. They have a big accounting system, and that's how the New York Stock Exchange was going to account for all of that. So it's actually a protection of the property within Wyoming from being co-opted by those who would like to make money from selling our natural assets that are not the landowner.
Okay. Senator Larson.
Thank you, Mr. Chairman. I'm kind of confused on page 3, line 9. Specifically, about the holdings outside the state of Wyoming. Are they referring to those properties outside the state of Wyoming in the bill, proposed bill? And if so, I wondered if you could maybe read that different to say from land it holds outside the state of Wyoming.
Anna.
Chairman Eklund, Senator Larson, that does refer to land outside the state of Wyoming, and I could have made that more clear. It might be worth amending that to land outside the state of Wyoming that is held by a natural asset company or something along those lines.
Mr. Chairman, that's kind of what I was wondering too. So when we get to that point, I might make an amendment.
Okay. Further questions or discussion on it?
Mr. Chairman,
Bill, go ahead.
and so back to page, where is it? So page 2. And this is section Romanet 2, so start on line 17. It says, manage, maintain, restore, and grow the value of natural assets and the production of ecosystem services in an area. Well, I don't have any definition of ecosystem services in the bill, but let me give you a couple of ideas. That's what at least is, if you Google what is ecosystem services. Type 1, their provision services are characterized by the ability of humans to obtain products from ecosystems such as food, water, resources, including wood, oil, genetic resources, or medicine. So are we prohibiting that manage, maintain, restore, and grow value of natural assets and productions of ecosystem services? And so this is, I guess that's what it says, is this is what the purpose of those ecosystem services are. But then when we get to the prohibition back on it should be unlawful for natural assets. Just trying to figure out, are we going to shoot ourselves in the foot by limiting the ability of private landowners to market any of these components, food, water, wood, fiber? I don't know. That's what I'm trying to find out. We don't have a definition of ecosystem services in the bill.
Okay, we may have to do that somehow here. We haven't had any public comment on this, have we? I think we probably could get some opinions, see if anybody else understands this crazy way of guess. Mr. McGagna. Guessing you have an opinion on it, just like I do, but I just still can't believe it could be done on a New York Stock Exchange. I have a hard time believing that they could take the conservation easement and sell it on the exchange or change it at all. But if you have an idea.
Thank you, Mr.
of this
Chairman.
bill.
First of all, we certainly strongly oppose the effort that was made to sell conservation credits or these types of things on the New York Stock Exchange for a couple of reasons. One of the most disturbing to us at that point in time was that it included interests on public lands, and we could see a federal land agency granting some of those to a natural asset company, and all of a sudden we have a partner out there that we can't work with. But back to the private sector part of it, I guess a couple of concerns I have with this bill. First of all, it seems to focus on conservation easements, and conservation easements by definition are perpetual agreements. And I think they, by their terms, whether it's done by our entity or by others that I'm familiar with, have probably the strongest protections against this type of a thing happening. And so I'm more concerned in terms of that and would suggest if this goes forward, perhaps on page 3, line 5, instead of a conservation easement, talk about an interest, a conservation interest in land. And maybe we can even go a step further, somehow define that as being independent from the other interests. And I'm not sure what the wording would be. Perhaps Representative Craig would help. So it's an interest that's independent. It's not an interest that's held by the landowner, the typical landowner. And that would go back to on page 2 to line 7 again, striking conservation easement and describing what we're really talking about is an entity that holds a conservation interest in land independent of the it is a property right, so we can't use that term. I'm a little puzzled for what the term would be, but distinguish it as it's a separate interest. And then providing that those cannot be sold through a national securities exchange. Because there are, I have been in contact with some of these, what have been termed natural asset companies who would be interested in coming into Wyoming and with provision that they could not sell those credits. They would hold the credits, they would work with the landowner, provide the landowner with funding to do certain types of enhancements or maintain certain conditions on their property. And those companies would get entities out there that are looking for conservation credits or that to invest in their company, provide the dollars that then the landowner would share in, but those investors would not acquire any property interest in the lands that are being involved. So I think there's a fine line there that done the right way, some of this can provide an opportunity for landowners, and done the wrong way, it's seriously a threat to landowners. And I think we need to be careful that we use some language that doesn't have an unintended consequence. With that, Mr. Chairman, I'd be happy to answer any questions.
So these companies already exist within Wyoming and have tried to do business, or is that theoretical that they could?
Mr. Chairman, I'm not sure that they exist registered to do business in Wyoming. They exist on a national level, and they would be interested. They see Wyoming as a place where some of this work could be done voluntarily with landowners, and they're interested in having at least some initial discussions on what those opportunities might be. It certainly isn't anything that's happening today, to my knowledge.
All right. Questions, committee?
Mr. Chairman,
Okay, Senator Larson.
I'd like to ask Mr. McCann, so currently do the conservation easements have a stipulation that they can't get credits for this and then sell them?
Mr. Chairman and Senator Larson, the easements that we do, and I believe this is common to easements done by the other entities operating in Wyoming, have strict provisions that the interest, the value, the interest in the easement, which is an interest in the land, must be held by the entity that procured the easement in their Wyoming, or they have special provisions that if for some reason that entity went out of business or something, they have to be transferred to another entity that is similar in nature and is committed to upholding all the terms of the easement. They can't just sell credits off of the easements, to my knowledge.
Does that agreement and that transfer have to be agreed on by the actual landowner?
It has to be agreed on by the landowner, and it has to be agreed upon by any entity that puts substantial financial and contribution into the acquisition of the easement to begin with, such as the Wyoming Wildlife and Natural Resource Trust, for example, which has helped with many of these easements.
Okay, questions? More questions, committee? Thank you, sir. Any further public comment? Okay, close public comment. Committee, what's your pleasure? Okay, we've got a moved by Kolb and seconded by Winter? No. Seconded, okay. All right, a question by Representative Winter.
Yes, thank you, Mr. Chairman. This whole effort appears to me to be some kind of a world entity that's trying to take over Wyoming, and I cannot sit here and not say anything. It's to me, this is a fairy tale that somebody has come up with that makes no sense, and it's going to adversely affect the state of Wyoming and other states in this part of the world. So I cannot understand how we could even consider something like this as a benefit to the state of Wyoming. Thank you.
So are you talking about the natural asset companies or the prohibition of those companies in Wyoming?
These natural asset companies, to me, are, like I said, a fairy tale. It's something that we should not even be considering, because I think it's something that's being proposed by somebody outside of this country. And if it isn't, they're affiliated. The people are affiliated with someplace outside of this country. So that's kind of my feelings.
Okay. Further discussion. Chairman Steinmetz.
And just to further elaborate, this is a bill to prohibit that in Wyoming. So, yeah, it might need some modification to say that to adjust it, but the bill is designed to prohibit the natural asset companies from selling credits in Wyoming.
So go ahead, Representative Craigo.
Thank you, Mr. Chairman. And I mean, I agree that we do not want natural asset companies selling interests. And I think we're all in agreement on that. I think what we need to hone in on and what we need to fix if we move the bill forward is we don't want to limit private people from doing whatever they want with their own places, whether that's entering into conservation easements or selling carbon credits on their own ranch. I don't want to stop that. Those folks can make that decision on their own. I don't believe any of us want to stop that. We just need to make sure the language that we're going to put in the statute book clearly addresses what we're trying to do and isn't too broad. And so, I'll probably vote for it to keep it moving forward, but because I don't think we have time today to get into the weeds and figure out exactly what it needs to say. But if we're going to move it forward, I think we need to be committed, and I'm willing to help do that, but make sure we're not affecting private interests.
Yeah, and I think that possibility kind of came up when we were talking about selling things other than the products and what have you. Senator Hicks brought that up.
Yeah, Mr. Chairman, and I agree with the sentiment. I don't want to create some world market for some entity to come and acquire a bunch of property and land and then sell something that's antithetical to the values that we hold here in the state. On the flip side of this, and I just look at a lot of times when we pass this legislation, who's going to monitor these natural asset companies that may or may, which currently they can't trade these as stocks, but how do we monitor it? How do we measure it? And then what do we do if they find out that somebody's done this? So what's the penalty? And so the consequences of somebody coming in here and actually just ignoring our statutes and do it has the consequences of absolutely zero. First, we got to find out who they are and what they're doing and how to track them. And so what agency is going to be responsible for that? I agree with everything my colleague said. I just don't want to put stuff in the green books that has absolutely no ability to research, identify, and then enforce. It's a statement, and this would be more in the form of a resolution than actually codifying something into law until we have all these other components as to how is this going to be tracked by the Secretary of State's office? Do they have to register as a natural asset company with the Secretary of State's office? That may be a way to track them. You cannot do business in the state of Wyoming as a natural asset company until you have filed as a business entity with the Secretary of State. That's a tracking mechanism to know whether they're even operating in the state of Wyoming. And so, again, I agree with the sentiment of the bill. I think we all share those same values. We don't want to see this marketing Wyoming to research and be a speculative market to be traded around the world. I'm just worried about the current format without going through all these other provisions as to what we're actually accomplishing. That's my concern.
Representative Winter.
Yes, thank you, Mr. Chairman. We keep talking about these natural asset companies and conservation easements and so forth being strictly with private lands. But I think it goes further than that. I think and you know, this might be some kind of a scary thing that that I'm dreaming up anyway, that I think these efforts are geared more towards not just the private lands, but our federal lands as well. And I think we need to put a stop to it in whatever manner possible to at least take the lead to stop any kind of a natural asset company effort, if that's what they want to call them. I could call them something else, but I won't. Thank you.
Okay, any further discussion? Representative Schlegel.
I think Senator Hicks hit on one of the biggest things with this. These natural assets is pollination, clean air, stuff that we really can't quantify, we can't regulate and measure, so it makes it really difficult to really regulate this and to come up with something that it doesn't. I don't have any real solutions other than what's in front of us here, but I would tend to agree with Senator Hicks that this really doesn't fix the issue we have. I mean, and I don't know how we can, I guess I haven't come up with the idea of how we can actually solve this issue, but I feel that's our biggest problem. We're looking at issues that have never been held and considered entities to be owned in before. Basically, all these things are shared by all of us in common. And it really makes it tough when you're trying to quantify them and hold ownership on stuff that you can't hold. I mean, we can't hold a bee from carrying pollen over to our neighbor's flowers. Yeah, if we stir up some dust, that's gonna mess up his air and make the quality less quality, but we don't have a lot of control in a lot of these issues. I mean, and I think that's where our difficulty really comes from here. But anyway, that's just what my thoughts are.
Yeah, Mr. Chairman, if I may.
Senator Ide.
Oh, go ahead.
Just a quick comment. Representative Winter brought up, I think, you know, there's been a push for, you know, conservation as part of the multiple use of FLTMA and, you know, federal lands. And I think the bigger issue that needs to be addressed, as well as these conservation easements, is, you know, 47% of our state is controlled by the federal government. And I don't know if we can work this bill and incorporate that in so it's not specifically, you know, conservation easement stuff, but keep that front and center as Representative Winter said. We've got, you know, we don't govern or legislate half of our state from this body right here. Federal government does. So just a point of information. Thank you.
Other discussion. Representative Alderman.
Thank you, Mr. Chairman. I think, folks, it's time that we start working on this, not next year. Let's get to working on this today, as we are, and in the next session, because this is coming at us. We saw it, and we dodged a bullet with it last year because of our great Harriet Hageman. But it's not done, folks. It's coming at us. Let's pass this and move it on. Thank you.
Further discussion? How about amendments? We've talked a little bit about it. Got any changes you'd like to do on this bill right now before we vote?
Mr. Chairman,
Yes, go ahead, Senator Larson.
I think I'll bring that. Hopefully, it's a simple amendment that maybe you would agree to on page 3, line 9. Delete after credits if it has holdings, and insert from land it holds. So the sentence would read, this subsection shall not prohibit a natural asset company from selling its credits from land it holds outside the state of Wyoming.
Everyone got that? Okay, is there a second to that amendment? Seconded by Chairman Steinmetz. Discussion on the amendment? Okay, all those in favor of that amendment say aye.
Aye.
Opposed? Okay, that amendment passes. Any further amendments? Senator Ide.
Thank you, Mr. Chairman. Mr. McGagnon brought up a potential amendment that I think may help with the federal land issue on page 3, line 5, where he suggested, if I've got this right, having interest in land that may kind of dovetail into, leases, or if, multiple use gets expanded for whatever reason, they keep pushing that. And so I would make an amendment to that, including after conservation, interest in land. And I think the other spot was in line 13 of page 3. After conservation, instead, cross out easements and put interest in land.
Okay.
Mr. Chairman,
Senator Larson.
would that, I would ask the bringer of that if that would maybe include on page 2, where it refers to conservation easement?
Yes, I just missed that one, and I would include that as the amendment on this as well.
So we would clean out specifically conservation easements with your motion. Now, have we got a second on that?
I'll second.
Seconded by Banks. Question on the amendment? Question being called, all those in favor? Oh, you have a question. Okay. Go ahead, Representative Davis.
Well, on the easements, they're most generally on private land. So the way I read that holds a conservation interest on land. What kind of land are we talking about? Is it private? Is it?
Any land.
No, well, I don't know if putting private land in there would be a friendly motion to that, or amendment to that motion? Or amendment to that amendment, or however that would work.
Private property rights.
Senator Ide.
Thank you, Mr. Chairman. I haven't thought about that a lot, but I think this is pretty broad, and I like it that way. I can see if there's a private piece of land that, wants to sell carbon credits, I guess we should have that discussion. Maybe somebody knows more about that than I do, but, any discussion, I'd be glad to. Otherwise, I'd prefer not to accept that amendment.
Any further discussion? Okay, Ready to vote on the amendment. All those in favor say aye.
Aye.
Opposed? Okay, that amendment passes. Any further discussion or amendment? All right, we're ready to vote, it looks like.
Mr. Chairman, this is roll call vote for 25 LSO 0309, Protect Wyoming's Lands Act as amended. Senator French,
Aye.
Senator Hicks,
No.
Senator Ide, Senator Kolb,
Aye.
Senator Larson,
Aye.
Representative Allemand,
Aye.
Representative Allred,
No.
Representative Banks,
Aye.
Representative Conrad,
No.
Representative Crago, Representative Davis,
No.
Representative Slagle,
Aye.
Representative Winter,
No.
Co-Chairman Steinmetz,
Aye.
Chairman Eklund.
Aye.
That passes sponsorship.
Passes both houses then. Okay, that bill passes. Committee, unless we have other business, I think we're gonna adjourn this. I need your little sheets of paper if you haven't brought them up here to us. So this meeting is adjourned. Everybody drive home safely. I don't know how snowy it is north and west, but if it gets very bad, just find a motel and not risk it. Is it? Okay. Drive carefully. And thank you for your good work.